A young millionaire fighting to save his late father's legacy watched 13 expensive lawyers fail him one after another, until a 62-year-old two-year-old cleaning lady with an 8th-grade education walked into his office at midnight and solved his impossible legal crisis in 4 minutes flat. Before we start the story, tell us in the comments what city you are watching from. And at the end, don't forget to rate this story from 0 to 10. Enjoy the story. The courtroom was silent as the judge prepared to strike his gavel. One final blow that would strip away everything his father had built. Every scholarship fund, every community center, every dream of justice for the forgotten. 13 lawyers had tried and failed. His fortune was about to become the property of the very corruption his father had died fighting against. And then, from the back of the courtroom, a woman in a gray cleaning uniform stood up and spoke 7 words that changed everything. But to understand how a janitor became the most important person in a courtroom full of Ivy League attorneys, we have to go back to where it all began. The thing about inheriting a fortune at 28 is that nobody tells you about the weight of it. And I don't mean the money itself, though God knows that's heavy enough. I'm talking about the ghosts that come with it, the expectations, the eyes watching your every move, waiting for you to prove you're worthy of a dead man's dream. My name is Jackson Reeves, and 6 months ago, I became the sole heir to the Reeves Foundation, a $300 million empire dedicated to one singular mission: providing legal defense for people who couldn't afford it. My father, William Reeves, had built it from nothing. He'd been a public defender who'd watched too many innocent people go to prison simply because they were poor. So he'd done something about it. He'd worked himself to the bone, invested brilliantly, and created something that actually mattered. Then he had a heart attack in a courtroom while defending a single mother accused of a crime she didn't commit. He died the way he'd lived fighting for someone else. And now I was sitting in his office at 11:47 p.m. on a Thursday in October, surrounded by the kind of silence that makes your ears ring. The building was empty except for the night security guard and presumably the cleaning crew, though I hadn't seen anyone in hours. I'd sent my assistant home at 8, told her I needed to think. What I really needed was a miracle. The papers spread across the mahogany desk, my father's desk. Though I couldn't bring myself to think of it as mine, told a story that would have broken his heart. Someone was trying to take it all away. Not just the money, the entire foundation, everything he'd bled for. 6 months. I'd had 6 months to prove I could carry his torch. And I was about to lose. It all to a legal technicality so obscure that it had taken the opposition's lawyers 3 years to find it buried in a 1947 corporate law statute that nobody even knew still existed. The paperwork before me was dense, suffocating, technical language that twisted and turned like a snake eating its own tail. I'd read it 17 times, and each time the knot in my chest pulled tighter. Here's what it came down to. My father had structured the foundation in a specific way to protect it from being absorbed or dissolved. He'd created what's called a perpetual charitable trust with restrictive covenants. Basically, it meant that the foundation couldn't be sold, couldn't be changed from its core mission, and couldn't be controlled by anyone outside the family line. It was supposed to be bulletproof. But 3 years ago, a corporate raider named Seth Malcolm had started circling. Malcolm was everything my father had despised: a man who'd made billions buying struggling companies, gutting them for parts, and leaving thousands of people unemployed in his wake. He collected lawsuits like other people collected stamps, and he had a personal army of lawyers who specialized in finding loopholes in seemingly airtight legal structures. Why did he want the Reeves Foundation? Simple. We'd won a case against one of his subsidiaries 2 years ago. A wrongful termination suit that had cost him $40 million in damages and made him look like the villain he was. Malcolm didn't forget things like that. He didn't forgive them either. So he'd set his legal machine on us, digging through every document, every filing, every piece of paperwork related to the Foundation's creation. And somehow, impossibly, they'd found something. The statute they'd dug up, California Corporate Code Section 5142, subsection 7C, had been written in 1947 as part of a post-war reform effort. It required that all charitable trusts established, with assets exceeding a certain threshold, had to file a specific forms CT-19 with the state within 60 days of the founder's death if the trust was being transferred to a surviving heir who was not a spouse. My father had filed dozens of forms when he'd set up the Foundation's transfer protocols. Dozens. His lawyers had been meticulous. But Form CT-19 wasn't on any modern checklist because everyone thought the statute had been superseded by later reforms. Apparently, it hadn't. Through some bizarre quirk of legislative oversight, that 1947 requirement was still technically active, and my father's lawyers had never filed it. The deadline had been 60 days after his death. We were now at day 183. According to Malcolm's interpretation, backed by a small army of legal precedent they'd somehow assembled, this filing failure meant the trust transfer was invalid. And if the transfer was invalid, the Foundation's assets would be considered orphaned charitable property, which under another obscure provision could be petitioned for by any party who could demonstrate they'd been financially harmed by the organization. Malcolm was that party. He'd been harmed to the tune of $40 million. If the judge agreed with Malcolm's interpretation, the Foundation would be dissolved and its assets liquidated to compensate him. Everything else, the scholarships, the legal firms, the community centers in 12 cities would simply cease to exist. I'd hired 13 lawyers over the past 4 months. 13. Each one had come with impeccable credentials and impressive hourly rates. Each one had read the case, analyzed the statutes, reviewed the precedents, and ultimately told me the same thing in slightly different words. "I'm sorry, Mr. Reeves, I don't see a way out of this." The most recent consultation had ended 3 hours ago. Douglas Mitchell from Preston and Walsh, a firm so prestigious they didn't even have a website because they didn't need one, had sat across from me with the expression of a doctor about to recommend hospice care. "The statutory language is unambiguous," he'd said, his voice carrying that particular tone of sympathy that somehow made everything worse. "Your father's lawyers made an understandable mistake, but it's a fatal one. The filing deadline has passed. There's no provision for late filing, no exception for good faith errors. I've consulted with 4 specialists in charitable trust law, and they all agree. Your best option at this point is to negotiate a settlement with Malcolm. Maybe you can convince him to preserve some portion of the Foundation's mission in exchange for dropping the appeal." "Malcolm doesn't negotiate," I'd said. "He destroys." "Then I'm afraid you're going to be destroyed." Mitchell had stood, collecting his briefcase with the efficiency of a man who had other clients waiting. "I'm sorry I couldn't give you better news. My firm will send you our final invoice. 13 lawyers, 13 invoices that had collectively drained nearly $2 million from the Foundation's operating budget money that should have been used to defend people who actually needed it. And for what? To be told over and over again that my father's legacy was going to die because of a piece of paper nobody had filed. The preliminary hearing was in 6 days. Judge Catherine Morrison, known for her strict interpretation of statutory law, would review the arguments and likely issue a summary judgment. Once that hammer fell, it was over. I pressed my palms against my eyes until I saw stars. The exhaustion was a living thing now, a creature that had taken up residence in my bones. I hadn't slept more than 3 hours a night in weeks. Coffee had stopped working sometime around lawyer number 7. Now I just existed in a constant state of exhausted desperation. My phone buzzed. A text from my younger sister, Riley. Any news? I didn't respond. What was I supposed to tell her? That I'd failed? That I was going to be the Reeves who let it all slip away? Riley was in her second year of medical school, planning to work with underserved communities. She'd grown up watching Dad fight for people just like I had. This was going to break her heart. The office was too quiet. The kind of quiet that makes you aware of every small sound, the hum of the ventilation system, the distant groan of the building settling, the ticking of the antique clock on the shelf behind me. Dad's clock. He'd bought it at an estate sale 30 years ago for $15 because he'd liked the sound it made. Time is the only thing we can't make more of, Jackson, he'd told me once. Use it like it matters. I'd been 12. It was the kind of thing parents say that doesn't really land until years later, when you're sitting in their office trying to figure out how to honor everything they'd built. A soft knock on the doorframe made me look up. She was standing in the doorway with a gray cleaning cart beside her, a woman I'd seen around the building for months, but had never really noticed. You know how that is, don't you? You see people without actually seeing them. The invisible workforce that keeps the world running while everyone else is focused on their own importance. She was older, early 60s. I'd guess with steel-gray hair pulled back in a practical bun and deep lines around her eyes that spoke of a lifetime of smiling through hard things. She wore the standard gray uniform of Midwest Building Services, the company that held the cleaning contract for our office complex. Her name tag read, Dorothy Walsh, in faded letters. "I'm sorry to disturb you, Mr. Reeves," she said, her voice carrying the particular warmth that some people just have naturally. "I didn't realize anyone was still here. I can come back and clean this office later if you need more time." "No, it's fine," I said, sitting up straighter and trying to look like less of a disaster than I felt. I should probably head home anyway. It's late, but I didn't move. Couldn't, really. Where was I going to go? Back to my apartment to stare at the ceiling for a few hours before coming right back here? Dorothy didn't leave either. She stood there for a moment, her hand still on the handle of her cleaning cart, studying me with an expression I couldn't quite read. Concern, maybe? Or just the kind of polite interest that people show when they know they're supposed to say something but aren't sure what. "Forgive me for saying so," she said finally, "but you look like you're carrying the weight of the world on those shoulders." I let out a laugh that sounded more like a cough. Something like that. "Your father was a good man," she said quietly. "I used to clean his office when he worked late, too. He always took the time to ask about my day, ask about my grandson. Most people don't do that." She paused. "I was real sorry to hear about his passing." Something in my throat tightened. "Thank you. That means a lot." She wheeled her cart a little further into the room. "If you don't mind me asking, and you tell me if I'm overstepping, but what's got you here past midnight looking like the world just ended?" I should have said it was nothing. Should have given her the polite brush-off that people in my position are supposed to give to people in hers. That's how the world works, isn't it? Clear boundaries, professional distance. But I was so tired, so completely hollowed out by months of fighting a losing battle that I didn't have the energy to pretend anymore. "Someone's trying to take away everything my father built," I said. The words came out flat, emotionless. I'd said them so many times to so many lawyers that they'd lost their power to hurt. And I can't stop it. I've tried everything, hired every expert I could find, and it's not enough. Dorothy moved closer, her movements slow and deliberate. She picked up one of the documents from my desk, the summary brief that outlined Malcolm's entire case. I started to protest, to tell her it was confidential legal material, but something stopped me. She was reading it. Not skimming, actually reading it. Her eyes moved across the dense legal text with a focus that surprised me, her lips moving slightly as she processed the words. "This about that old Form CT-19 requirement?" she asked after a moment. I stared at her. How do you How do you know about Form CT-19? She looked up from the paper, and there was something in her eyes that I hadn't expected. Intelligence. Sharp, clear, and very awake. Because 30 years ago, Dorothy said slowly, I was a paralegal in a firm that specialized in charitable trust law, and I worked on a case that dealt with this exact same statute. The office suddenly felt very different. The exhaustion was still there, the desperation, the weight of everything that was about to fall apart. But now there was something else, too. A tiny, fragile flutter of something that might have been hope. Tell me, I said. And Dorothy Walsh, a 62-year-old woman in a gray cleaning uniform with an 8th-grade education on her official employment records, smiled. Mr. Reeves, she said, I think I might be able to help you. Dorothy set the paper down on my desk with the kind of careful precision that spoke of old habits, professional habits. Her hands were weathered the hands of someone who'd spent decades doing hard work. But the way she handled that document wasn't the way a cleaning lady handles papers she's dusting around. It was the way a lawyer handles evidence. You were a paralegal, I said, and it came out more like a question than a statement because my brain was still trying to catch up with what was happening. But you're cleaning offices at 62? She finished the sentence for me. No bitterness in her voice, just simple acknowledgement of a fact. Life doesn't always go the way you plan it. Mr. Reeves. But that's a longer story, and right now, I'm guessing you need to hear about Form CT-19 more than you need my autobiography. I nodded, unable to form words. My heart was doing something strange in my chest, beating too fast and too slow at the same time. If that's even possible. Dorothy pulled up one of the leather chairs that faced my desk and sat down without asking permission. There was something quietly dignified about the way she moved, something that suggested she'd sat in chairs like this before, in offices like this. Back when her uniform was different, 1995, she said, settling back and folding her hands in her lap. I was working for a firm called Brennan & Associates. They don't exist anymore. Got absorbed by a bigger firm in '98. We had a client, the Henderson Foundation, trying to transfer assets after the founder died. And someone challenged it on the exact same grounds you're facing now. Said they'd missed the Form CT-19 filing deadline. What happened? My voice sounded strange to my own ears. Desperate. Raw. We lost, Dorothy said simply. The foundation was dissolved, assets liquidated. I watched a man's entire life's work get carved up and sold off because of a piece of paper nobody had thought to file. It was... She paused, and something flickered across her face. Old pain. It was one of the worst days of my career. I went home that night and cried for 3 hours straight. The hope that had started to flutter in my chest faltered. Then how is this supposed to help me? If you lost... I lost because we didn't know what we know now, Dorothy interrupted, and there was steel in her voice. Back then, in '95, we accepted what the statute said at face value. We fought it on procedural grounds, argued that the requirement was obsolete, that subsequent reforms had created alternative compliance pathways, and the judge shut us down on every argument because technically, legally, we were wrong. The statute was still active. We hadn't filed. End of story. So what's different now? Dorothy leaned forward, and her eyes a clear, sharp gray that reminded me of winter sky locked onto mine. What's different is that I spent the next 3 years obsessing over that case. Every night after work, I went to the law library and researched. I pulled every case that had ever cited that statute. I read legislative histories. I tracked down the original committee reports from when it was written in 1947. I became an expert in a piece of law that 99% of lawyers don't even know exists. Why? The question slipped out before I could stop it. Why spend 3 years on a case you'd already lost? Something sad crossed her face. Because I couldn't let it go. Because watching that foundation die felt like watching my own failure on permanent display. Because I needed to know if there had been a way to save it that we'd just missed. She straightened her shoulders, and eventually I found one. I was gripping the arms of my chair so hard my knuckles had gone white. Tell me. The statute requires filing within 60 days of the founder's death, Dorothy said, shifting into a different mode, now the mode of someone explaining complex law to a client who needs to understand every word. That part's true, and that deadline is absolute. Your father's lawyers missed it. That's also true, but here's what Malcolm's lawyers aren't telling the court, and what none of your 13 expensive attorneys apparently caught. She stood up and moved to the desk, spreading out several of the documents that I'd been staring at for hours. Her finger landed on a specific paragraph in Malcolm's petition. They're claiming that the missed filing means the trust transfer is void. But that's not what the statute actually says. It says, and this is the exact language, that failure to file shall render the transfer incomplete pending administrative review. She looked up at me. See the difference? I stared at the words. I'd read them 100 times. They looked the same as they always had: dense, impenetrable legal language that might as well have been written in ancient Greek for all the clarity it offered me at midnight after 4 months of losing. I'm not seeing it. Dorothy's expression softened. You're exhausted, and you've been told over and over that this is hopeless. So your brain is seeing what it expects to see. But look at the word choice. Incomplete doesn't mean void. It doesn't mean invalid. It means exactly what it sounds like: the process isn't finished yet. Something in my chest started to wake up. But the deadline has passed. If the filing deadline is absolute, and we've missed it, how can the process continue? Because there's a second part to that statute that everyone forgets about, Dorothy said. And now there was something almost fierce in her voice. Section 5142, subsection 7c, paragraph 2. Want to know why everyone misses it? Because it's written in the most convoluted bureaucratic language you've ever seen, and it cross-references 2 other code sections that were repealed in 1963, which makes most lawyers assume the whole paragraph is dead law. She pulled out her phone, an old model, the kind with actual buttons, and opened what looked like a notes app. I watched as she scrolled through page after page of typed text, organized with headers and bullet points. I keep notes, she said, almost apologetically. Old habits. Here, let me read you the relevant section. This is from the original 1947 statute. She cleared her throat and read, in cases where the prescribed filing deadline has passed without submission of required documentation, the transferee or their designated representative may petition the State Charitable Trust Review Board for discretionary acceptance of late filing, provided that a. Substantial compliance with the intent of this code section can be demonstrated through alternative documentation, b. The delay in filing was not the result of willful negligence or intent to defraud, and c. The petitioner can demonstrate that the charitable mission of the trust has been actively maintained during the period of administrative incompleteness. She looked up from her phone. That review board? It still exists. It's called the California Charitable Assets Oversight Board now, but it's the same entity with the same discretionary authority. And nobody, not Malcolm's lawyers, not any of your 13 attorneys, has mentioned it in any of their filings. I felt like I'd been punched in the chest and given oxygen at the same time. You're telling me there's a board that can accept a late filing? With the right petition and the right evidence, yes. Dorothy set her phone down. It's never a guarantee they have full discretion to accept or deny. But here's the thing. In the 3 years I spent researching this, I found 7 cases where this provision was invoked. 7 cases spanning from 1952 to 1994. Want to know how many times the board denied the petition? How many? 0. Dorothy smiled, and it was the smile of someone sharing a secret that could change everything. Not once did they deny a good faith petition that met those 3 criteria. Not once. The board's entire purpose is to prevent charitable assets from being dissolved over technicalities when the charitable mission is still being actively served. My mind was racing now, exhaustion forgotten, replaced by something electric and sharp. So we file a petition with this board, demonstrate that we meet those criteria, and they can essentially cure the missed deadline? That's exactly right. And if they accept it, then the trust transfer is complete, which means Malcolm's entire case collapses, Dorothy finished. Because he's not challenging the validity of the trust itself, or your father's right to create it. He's challenging the transfer to you based solely on this filing failure. If the board retroactively accepts the filing, there's no failure. There's no incomplete transfer. There's no orphaned charitable property. There's just a properly transferred trust that's been continuously serving its mission for the past 6 months. I stood up so fast my chair rolled backward and hit the wall. How did 13 lawyers miss this? I stopped myself. It didn't matter how they'd missed it. What mattered was that there was a way forward. An actual, real, possible way to save everything. But even as hope surged through me, doubt crept in behind it. Because if this was real, if this was actually possible, why hadn't anyone else found it? Dorothy, I said slowly, why didn't this come up in any of the legal research? I've had some of the best firms in the state working on this. They have junior associates whose entire job is to find obscure provisions exactly like this one. She nodded, like she'd been expecting the question. Because modern legal research databases don't cross-reference well with pre-1950 statutes that have been amended multiple times. The language I just read to you? It's not in the current published version of the California Corporate Code. It's in the original legislative text and subsequent administrative rulemaking, documents that established the review board's authority. Unless you know to look for those specific historical documents, you'd never find it. But you found it. I found it because I spent 3 years with my nose in physical archives at the State Law Library, reading microfiche and original committee reports that haven't been digitized. I found it because I was obsessed and heartbroken and determined to understand how we'd lost. Dorothy's voice went quiet. And I found it too late to help the Henderson Foundation. But maybe not too late to help yours. I walked around the desk and stood in front of her. This woman in a cleaning uniform who'd just handed me something that 13 lawyers and $2 million couldn't find. How long do we have to file this petition? The preliminary hearing is in 6 days, right? When I nodded, she continued. Ideally, you want to file the petition before that hearing and inform the judge that there's an active administrative process underway. It won't stop the hearing, but it will give the judge grounds to stay any ruling pending the board's decision. The board typically reviews petitions within 30 days. Can you help me draft this petition? Dorothy hesitated, and I saw something complicated cross her face. Mr. Reeves, I'm not a lawyer. I haven't worked as a paralegal in almost 20 years. I'm not asking you to represent me in court, I said. I'm asking you to help me draft a document that none of my actual lawyers seem capable of creating. We can have an attorney of record review and file it. But you understand this statute better than anyone I've met. You know what the board is looking for. She was quiet for a long moment, studying my face. Looking for something. Sincerity, maybe. Or maybe just trying to decide if this was real. If I was really asking a janitor to help save a $300 million foundation? My grandson, she said finally. She stopped, shook her head. His name is Tyler Walsh. He's 14. Smart kid, wants to be an engineer. Last year he got into some trouble at school. Nothing serious, just teenage stupidity. But the school wanted to press charges, and we couldn't afford a real lawyer. Dorothy's eyes met mine, and they were bright, with something that looked like tears, but her voice stayed steady. Your foundation assigned us an attorney, pro bono. She was young, just out of law school, working for no pay because she believed in what your father built. And she fought for Tyler like he was her own family. Got the charges dropped, kept it off his record, gave him a second chance. She took a breath. So, yes, Mr. Reeves, I'll help you draft that petition. Because your father's foundation gave my grandson a future, and the least I can do is try to return the favor. I had to look away for a second because something was happening to my face that I didn't entirely trust. When I looked back, Dorothy was already reaching for a fresh legal pad from the shelf behind my desk. "We've got 6 days," she said. "All business now." That's not a lot of time to build a comprehensive petition, but it's enough if we work smart. First thing we need to do is gather evidence that you've been maintaining the Foundation's charitable mission since your father's death. Case records, financial statements, documentation of services provided. The board needs to see continuous operation. "I have all of that," I said. "We've actually expanded services in 3 cities since I took over." "Good. That's very good." She was making notes in quick, efficient handwriting. "Next, we need to demonstrate that the filing failure wasn't willful negligence. That's the easiest part. Your father's lawyers clearly believed they'd filed everything necessary. We can get affidavits from them if needed. They'll cooperate? They'll have to if they don't want to face malpractice claims," Dorothy said dryly. "But I doubt it'll come to that. Most lawyers don't enjoy watching their mistakes destroy charitable organizations." "They'll help," she kept writing, her pen moving across the page in confident strokes. I watched her work. This woman who'd spent decades cleaning offices while carrying an expertise that could save everything my father had built. "Dorothy," I said, "why are you cleaning buildings? If you were a paralegal with this kind of knowledge, why—" She didn't look up from her notes. "My husband got sick," she said simply. "Cancer, no insurance. I left the firm to take care of him and burned through our savings paying for treatment that didn't work. When he died, I needed a job that would hire a 55-year-old woman with a 20-year gap in her resume. Midwest Building Services doesn't ask a lot of questions." She glanced up. "It's honest work." "I'm not ashamed of it." "I didn't mean I know what you meant." Her expression softened. "And I appreciate that you're seeing me as more than the person who empties your trash can. Most people don't. It's fine, I understand how the world works. But tonight, right now, I'm grateful that you actually listened when I said I might be able to help." I sat back down at the desk, on the same side as her now, both of us looking at the papers spread out like a battle plan. "What do we do first?" Dorothy smiled. "First, you're going to call the most detail-oriented lawyer on your staff and tell them to meet us here at 7 a.m. We need someone who can translate what I know into proper legal format. Then you're going to go home and get exactly 4 hours of sleep, because you're going to need your brain working at full capacity for the next 6 days. What about you?" "I'm going to finish cleaning this floor," she said, standing and returning to her cart. "And then I'm going to go home and pull out every file folder and notebook I've kept from my paralegal days. I documented everything from that Henderson case. Every research note, every statute, every cross-reference. It's all still in boxes in my garage, because I could never bring myself to throw it away." She paused at the doorway, her hand on the cart's handle. "Mr. Reeves, Jackson, I can't promise this will work. The board has discretion, and there's always a chance they'll see things differently than those 7 previous cases. But I can promise you this. We're going to give them a petition so thoroughly researched and perfectly argued that if they deny it, they'll have to write a 50-page decision explaining why." "That's all I can ask for," I said. And then, because it needed to be said, "Thank you for caring, for remembering, for being here." Dorothy Walsh, the woman who the world saw as invisible, who nobody had bothered to really look at for 20 years, smiled at me with the kind of warmth that reminded me why my father had spent his life fighting for people. "Your father noticed people," she said. "He saw them. Really saw them. You do the same thing I've watched you with the staff. with the clients who come through here. That's rare, Jackson, and that's worth fighting for. She pushed her cart out into the hallway, and I heard the soft sound of her humming something under her breath as she moved to the next office. I looked down at the papers on my desk, at the case that 13 lawyers had called hopeless, at the statute that had seemed like an impossible trap. And for the first time in 4 months, I didn't see the end of everything. I saw a woman in a gray uniform who'd remembered everything that mattered. I saw a chance. I didn't go home. I know Dorothy told me to sleep, but how could I? Instead, I spent the next 3 hours organizing every document we'd need, creating a timeline of the Foundation's activities since my father's death, pulling financial records and case files. At 3 a.m., I finally sent the email to Jennifer Brooks, the Foundation's lead staff attorney. The message was simple. Emergency meeting, 7 a.m., my office. Potential breakthrough in the Malcolm case. This is not a drill. Then I did go home, but only because Dorothy was right. I needed my brain working properly. I set my alarm for 6:30 a.m., which gave me exactly 3.5 hours of sleep. Not the 4 she'd prescribed, but close enough. I dreamed about my father that night. In the dream, he was standing in a courtroom, but instead of facing the judge, he was facing me. And he asked me a question I couldn't quite hear. I kept asking him to repeat it, but his voice got quieter and quieter until finally I woke up to my alarm. The question still lost somewhere in that space between sleep and consciousness. The thing about hope, though, once it starts, it's hard to stop. I arrived back at the office at 6:45 a.m. with 2 large coffees and a determination that felt different than the desperate determination of the past 4 months. This felt cleaner, sharper, like I was finally fighting the right battle instead of just fighting. Jennifer was already waiting in the lobby when I got there. She was 34, brilliant, and had turned down partnership tracks at 3 major firms to work for the Foundation because she actually believed in justice over profit margins. Her expression was cautious. She'd been through the ringer with me on this case, and I knew she was probably expecting another dead end. Dressed up as hope, please. Tell me this isn't about hiring lawyer number 14, she said as we rode the elevator. Up. It's not about hiring anyone, I said. It's about listening to someone we should have talked to 4 months ago. I explained everything as quickly as I could. Dorothy, the Form CT-19 research, the Charitable Assets Oversight Board, all of it. I watched Jennifer's expression shift from skepticism to interest to something that looked almost like excitement. The Henderson Foundation case from '95, she said slowly as we walked into my office. I remember reading about that in law school. It was used as a cautionary tale about the importance of comprehensive compliance research. But I don't remember anything about an administrative remedy. That's because they didn't know about it at the time, I said. But someone did the research afterward. Someone who spent 3 years making sure she understood every angle. And this someone is? The elevator dinged, and I checked my watch. 6:58 a.m. Right on time. Dorothy stepped out of the elevator wearing the same gray uniform, but she was carrying a large box that looked heavy. I moved to help her, but she waved me off with a smile. I've been carrying things for 20 years, Jackson. I can manage a box of files. Jennifer's eyes widened slightly as she recognized Dorothy from seeing her around the building. To her credit, she didn't say anything stupid. She just extended her hand. Jennifer Brooks, staff attorney. Jackson tells me you might have found something 13 other lawyers missed. Dorothy shook her hand firmly. Dorothy Walsh. And I didn't find it recently, I found it in 1998. It's just taken 27 years for it to become relevant again. She set the box down on my desk with a solid thump, and when she opened it, I saw what 3 years of obsessive research looked like. File folders, notebooks with color-coded tabs, photocopies of old statutes marked up with highlighter and handwritten notes in the margins. It was the kind of organized chaos that only makes sense to the person who created it. But when Dorothy started pulling out documents and explaining her system, I realized it made perfect sense. Every statute was cross-referenced with every case that cited it. Every administrative decision was linked to the regulatory authority that issued it. It was a masterclass in legal research, built one painstaking hour at a time by a woman who'd refused to accept that justice had been done. Jennifer picked up one of the notebooks and started reading. Then she picked up another. Her eyes were moving fast, and I could see her legal mind processing, connecting, understanding. "This is incredible," she said finally. "This is Dorothy. This research is better than most law review articles I've read. The level of detail, the thoroughness." "It was a hobby," Dorothy said with a slight shrug. "A sad hobby, maybe, but it kept me going after my husband died. Gave me something to focus on besides grief." Jennifer set down the notebook and looked at me. "If this petition works, if we can get the board to accept a late filing, this changes everything. Malcolm's entire case is predicated on the transfer being incomplete. But Jackson, you need to understand, this is untested in this context. Those 7 cases Dorothy found were all from decades ago. We don't know how the current board will respond." "But it's a chance," I said. "A real one." "It's more than a chance," Dorothy interjected. "It's a legitimate legal remedy that exists for exactly this situation. The board's enabling statute, which has never been repealed or modified explicitly, grants them authority to cure technical filing failures when the 3 criteria are met. And you meet all 3 criteria, clearly and demonstrably." Jennifer was nodding, already shifting into lawyer mode. "Okay, we need to draft this petition today. File it by end of business tomorrow at the latest. That gives the board 4 days before the preliminary hearing to acknowledge receipt and gives us grounds to request a stay." "Can you do that?" I asked. "Draft a petition that comprehensive in 1 day?" "Not alone," Jennifer said. She looked at Dorothy. "But with someone who's been preparing for this petition for 27 years. "Yes, we can do it," Dorothy smiled. "Then we'd better get started. I've got a shift tonight, but I'm free until 6 p.m. And that's how a 62-year-old cleaning lady and a 34-year-old foundation attorney spent 12 hours saving everything my father had built." Watch them work, Dorothy pulling statutes and cases from her meticulously organized files, Jennifer translating that research into formal legal language. The 2 of them falling into a rhythm that looked like they'd been colleagues for years instead of hours. Around noon, I ordered lunch. Around 4 p.m., I ordered more coffee. At 5:47 p.m., Jennifer looked up from her laptop with eyes that were tired but bright. "We've got it," she said. "Dorothy, can you review Section 3? I want to make sure I captured the administrative history correctly." Dorothy leaned over, reading the screen. Her finger traced along the words and she nodded slowly. "That's perfect. You've cited the original board decision from 1954 that established the precedent for discretionary acceptance. Good. And here she pointed to another paragraph. This is exactly the language we need about continuous operation." She straightened up and looked at me. "It's ready, Jackson. 32 pages, 57 citations, exhibits demonstrating every aspect of the Foundation's mission and activities since your father's death. If this doesn't convince the board, then nothing would." Jennifer hit print, and we all stood there listening to the copier produce the document that might change everything. When it was done, she assembled 3 copies, 1 for filing, 1 for our records, 1 for preparation. "I'll file this first thing tomorrow morning," Jennifer said. "And I'll hand-deliver a courtesy copy to Judge Morrison's clerk, with a motion for stay pending the board's review." "Will she grant the stay?" I asked. "Maybe. She's strict, but she's fair. If she sees there's a legitimate administrative remedy in play, she might pause things." Jennifer packed up her laptop. "But even if she doesn't, just having this petition on record changes our posture. We're not coming to her empty-handed anymore. We're showing her there's an entire regulatory framework that Malcolm's team has ignored. Dorothy was repacking her box of files, placing each folder back in its precise location. I watched her work. This woman who'd carried this knowledge for decades with nobody to share it with. Nobody who needed it. Until tonight. "Dorothy," I said, and she looked up. "I don't know how to thank you." "I don't know what?" "You already thanked me," she said gently. "You listened. You saw someone everyone else looks past. That matters more than you know." She finished packing, closed the box, and picked it up. "I need to get to my shift." "But Jackson? Jennifer?" She looked at both of us. "Win this. Not just because your father deserves it, though he does. Win it. Because there are people out there right now who need this foundation. People like my Tyler, who made a mistake and need someone to believe they deserve a second chance. We'll win it," Jennifer said with quiet certainty. "One way or another." Dorothy nodded and headed for the door. But she paused in the doorway, looking back. "Your father used to say something to me," she said. "When I'd clean his office late at night and he'd still be working, he'd say, 'Dorothy, justice doesn't happen in the big moments. It happens in the small ones, in the times when nobody's watching and it would be easier to give up.'" She smiled. "He was right about that, and he'd be proud of you for not giving up." Then she was gone, pushing her cart down the hallway toward whatever office she needed to clean next, carrying her box of research that had just saved a $300 million foundation. Jennifer and I looked at each other. "Did that really just happen?" she asked. "I think it did. A cleaning lady just did what 13 corporate law firms couldn't do." "Yeah." Jennifer laughed the kind of laugh that comes out when the pressure finally breaks. When impossible things become possible. When the universe reveals that sometimes the most important person in the room is the one nobody bothered to notice. "I'm filing this petition at 9 a.m. tomorrow," she said. "And then we wait." "And pray," I added. "And pray," she agreed. But as I left the office that night, walking past the other floors being cleaned by people in gray uniforms that most of the world never really sees, I wasn't praying for a miracle because the miracle had already happened. It had happened. When a woman who'd spent 20 years being invisible decided to speak up, it had happened when someone who'd lost everything, her career, her husband, her life as she'd planned it, chose to use her loss to prevent someone else from losing theirs. The miracle was Dorothy Walsh, who'd remembered everything that mattered. Now we just had to convince a board of bureaucrats to see what she saw. That justice sometimes comes in the form of second chances, late filings, and people who refuse to forget. Next, sir, the California Charitable Assets Oversight Board operated out of a building in Sacramento that looked like it had been designed by someone who believed government offices should inspire neither hope nor despair, just a utilitarian acceptance of bureaucracy. Gray concrete, small windows, the kind of architecture that says, "We process paperwork here," and nothing more. Jennifer filed the petition at 9:07 a.m. on Friday morning. She called me from the clerk's office, her voice carrying that particular blend of relief and anxiety that comes from launching something into the world that you can't control anymore. "It's in," she said. The clerk accepted it, stamped it, assigned it a case number. "Official filing date is today, October 23rd. They said the board meets every Thursday, and our petition will be reviewed at their next session on the 29th. I did the math in my head. The 29th was 6 days away. The preliminary hearing with Judge Morrison was on the 27th in 4 days, so we're asking Morrison to stay her ruling for a decision that won't come until after she's already scheduled to rule. Exactly. Jennifer sighed. I'm heading to her chambers now with the motion for stay. I've got the petition attached as an exhibit, along with a brief explaining why this administrative remedy is relevant. The clerk said the judge will review it this afternoon, and issue a decision by end of business today. What are our odds? There was a pause on the other end. In that silence, I could hear traffic, the sound of Jennifer walking, the ambient noise of a city going about its business, while my entire world hung in the balance. Honestly? 50-50. Morrison is tough, but she's also thorough. If she reads the petition and sees that there's legitimate statutory authority for this remedy, she might give us the stay. But if she thinks we're just throwing up a Hail Mary to delay the inevitable— Jennifer didn't finish the sentence. She didn't need to. Do the best you can, I said. That's all we've got. I'll call you as soon as I know something. She hung up, and I was left standing in my office with nothing to do but wait. You know what's worse than fighting a losing battle? Waiting to find out if you've finally found a way to win. I tried to work, tried to focus on the normal day-to-day operations of the foundation, reviewing case applications, checking in with the legal firms we funded in 12 cities, responding to emails from staff who didn't know that everything they were working on might disappear in 4 days. But my mind kept drifting back to that petition. 32 pages that Jennifer and Dorothy had crafted with the kind of care usually reserved for major Supreme Court briefs. I'd read it 3 times before Jennifer filed it, and each time I was struck by how different it felt from everything the previous 13 lawyers had produced. Those other legal documents had been defensive. They'd argued around the edges, looking for procedural technicalities or ways to challenge Malcolm's standing. They'd been the work of people trying to find a way out of a trap. This petition was different. It didn't argue. It explained. It walked through the history of the statute, the purpose of the board, the clear legislative intent that charitable assets should be protected when technical filing requirements were missed in good faith. It cited cases going back 70 years. It referenced administrative decisions that had never been published in mainstream legal databases. It was the work of someone who didn't just understand the law, someone who'd lived with it, studied it, refused to let it go for 27 years. It was Dorothy's expertise wrapped in Jennifer's legal precision. And if it worked, it would prove something that I think my father always believed: that the most important knowledge isn't always held by the people with the most impressive credentials. My phone buzzed at 11:43 a.m., a text from Riley. Heard through the grapevine that you filed something new. Don't suppose you want to tell your baby sister what's going on? I called her instead of texting back. Riley picked up on the first ring. Well, she said, skipping any greeting. Are we saved or are we screwed? We might be saved, I said carefully. There's a possibility, an administrative remedy that nobody knew about. We filed a petition this morning. Who's we? I thought lawyer number 13 was the last shot. I found myself smiling despite everything. You remember Dorothy, the woman who cleans the offices? The nice lady who always asks about my exams? Of course I remember her. What about her? Turns out, she used to be a paralegal who specialized in exactly the kind of law we needed. She found a way forward that 13 corporate firms missed. There was a long silence on the other end. Then Riley said very quietly, Are you telling me that the janitor solved our case? I'm telling you that a woman who happens to clean offices for a living, but who also happens to be one of the most knowledgeable people I've ever met about charitable trust law, showed me something that could save the foundation. Yeah. Dad would have loved that, Riley said, and I could hear her smiling. He always said the smartest people he knew were the ones everyone else ignored. He was right about a lot of things. So, what happens now? I explained the timeline, the board review, the preliminary hearing, the stay motion, all of it. When I finished, Riley was quiet for a moment. Jackson, she said finally, whatever happens, you know you've done everything you could, right? Nobody could have fought harder for this. If we lose, it won't be because you gave up. It'll be because sometimes the world is unfair and broken systems protect the wrong people. But you didn't quit, and you listened to someone everyone else overlooked. That matters. We talked for a few more minutes before she had to get to class. After we hung up, I sat there thinking about what she'd said, about fighting versus winning, about how sometimes doing the right thing doesn't guarantee the right outcome, but it was still worth doing. Jennifer called at 4:37 p.m. I grabbed the phone. So fast I nearly dropped it. Tell me. Morrison denied the stay. Jennifer's voice was flat, carefully controlled. She said that while the petition is interesting and well-researched, she doesn't believe the board's review process should delay proceedings that have been scheduled for months. She said we're free to pursue the administrative remedy simultaneously with the hearing, but she's not going to pause her calendar for it. I closed my eyes. So we're still facing the preliminary hearing in 4 days. We are. But Jackson, it's not all bad news. Morrison's written order includes a paragraph that surprised me. She said that if the board issues a decision favorable to us before she renders her final ruling, she'll take that into consideration. She's essentially saying that even if she issues a preliminary finding against us at the hearing, she might modify it if the board acts quickly, but the board doesn't meet until the 29th, 2 days after Morrison's hearing. Right. So here's what I'm thinking. We show up to that hearing, we present the petition as evidence that there's a legitimate administrative remedy in play, and we argue that Morrison should delay her final ruling, not the hearing itself, just the final ruling until the board weighs in. It's a long shot, but it's possible. I rubbed my temples. The headache that had been my constant companion for 4 months was back, pulsing behind my eyes. What does Malcolm's team know about all this? I copied them on the petition and the stay motion per court rules. So they've had it since this morning. Jennifer paused. And Jackson? They filed a response 2 hours ago. It's aggressive. How aggressive? They're calling the petition a desperate attempt to manufacture jurisdiction where none exists. They're arguing that the Charitable Assets Oversight Board has no authority to retroactively cure filing failures for transfers that have already been challenged in court. They've got their own battery of case citations, and they're pushing hard for Morrison to dismiss our administrative remedy as irrelevant to her proceedings. Can they do that? Can they just convince the judge to ignore a legitimate regulatory board? They can try. And if Morrison agrees with their interpretation that once litigation is filed, the administrative process becomes moot, then, yeah, she could rule that the board's decision, whatever it ends up being, doesn't matter to her courtroom. This was getting worse by the minute. We'd found a way forward, filed a petition that should work, and now Malcolm's lawyers were trying to convince the judge that the entire regulatory framework we'd discovered was irrelevant. Jennifer, be honest with me. What are our actual odds now? She was quiet for a long moment. When she spoke, her voice was steady but serious. Before Dorothy and this petition, we were at 0. Absolute 0. Now, maybe 20%. Maybe 25. It's still a long shot, but it's a shot. That's better than we had 2 days ago. 25%. 1 in 4 chance that everything my father built would survive. 3 in 4 chance that it would all belong to Seth Malcolm by the end of next week. Okay, I said. What's our next move? We prep for the hearing. I'm going to draft a response to Malcolm's opposition, file it Monday morning, and I want to bring Dorothy to the hearing. That surprised me. Why? Because judges are human beings, Jackson. And if Morrison sees the person who did this research, hears her explain how she found it and why it matters, that might carry weight in a way that my written arguments don't. I can't put her on the stand, she's not an expert witness, and she's not a lawyer. But I can cite her research in my oral arguments, and if Morrison wants to know more, Dorothy can be there to answer questions. Will Dorothy agree to that? I already asked her. Called her at home this afternoon. She said yes. I shouldn't have been surprised. Dorothy had spent 27 years preparing for this without knowing it. Of course she'd be willing to see it through. What do you need from me? Get some sleep this weekend. Stay off the stress eating and the caffeine overdoses. We need you sharp and present at that hearing. You're the face of this foundation. You're your father's legacy. Morrison needs to see that you're not some kid who inherited money. You're someone who's been actively, competently managing a charitable mission for 6 months. Can you do that? Yeah, I can do that. Good. I'll email you the prep materials Sunday night. We'll meet Monday morning to go over them. We hung up, and I sat there in the growing darkness of my office, watching the sun set over the city my father had loved. Somewhere out there, Dorothy was probably starting her night shift, pushing her cleaning cart through empty offices, while carrying knowledge that could change everything. Somewhere out there, Malcolm's legal team was probably celebrating their aggressive response, confident that they'd shut down our last desperate attempt. And somewhere out there, 13 lawyers who'd charged premium rates to tell me there was no hope were going about their lives, never knowing they'd missed something that a cleaning lady had found. The phone on my desk rang. Not my cell, the office landline. I almost didn't answer it, but something made me pick up. "Jackson Reeves," I said. "Mr. Reeves, this is Dorothy Walsh." Her voice sounded different on the phone, more formal, like she was making a business call. "I hope I'm not disturbing you." "Not at all. Jennifer told me you agreed to come to the hearing. Thank you for that. That's actually why I'm calling. I wanted to make sure you understood something." She paused. "Jackson, I've been thinking about this all day. About what happens if we lose." My chest tightened. "Dorothy, let me finish, please. If we lose, I need you to know that it won't be because the research was wrong or the petition was flawed. It'll be because sometimes the system is designed to protect power instead of justice. And if that happens, I don't want you blaming yourself. You fought harder than anyone could have asked. But it still might not be enough." "It might not be," she agreed. "But here's what I learned after the Henderson Foundation case, after all those years of research. Justice isn't just about winning in court. Sometimes it's about the fight itself, about proving that someone cared enough to stand up, to push back, to refuse to accept that the powerful always win." I found myself gripping the phone harder. My father cared about winning for people, about getting them actual results, not moral victories. "Your father cared about both," Dorothy said gently. "He understood that sometimes the fight creates a record for the next person, that sometimes losing the right way opens doors for future battles. I've seen the work you've done these past 6 months, Jackson, the cases you've taken, the people you've helped. That doesn't disappear, even if Malcolm wins. It does if the foundation is dissolved. The foundation is buildings and bank accounts. What your father really built was a belief that everyone deserves a chance at justice. That belief doesn't die with a court ruling. You carry it forward, whatever happens." We talked for a few more minutes, and when we hung up, I felt something shift inside me. The desperate panic that had been my constant companion was still there, but underneath it was something else, something steadier. I'd spent 4 months terrified of being the Reeves who lost everything, the one who'd be remembered as the failure who couldn't protect his father's legacy. But maybe that wasn't the right way to think about it. Maybe the real question was, had I fought with everything I had? Had I listened when someone offered help? Had I refused to give up even when it looked hopeless? The answer to all of those was yes, and if we lost anyway? If Malcolm won, and the foundation was dissolved and everything fell apart, well, then at least I'd know I'd done everything possible, that I hadn't quit, that I'd listened to a woman everyone else ignored, and given her knowledge the respect it deserved. That had to count for something. The weekend passed in a strange blur of preparation and forced calm. Jennifer sent me a 50-page briefing document Sunday night outlining every argument we'd make at the hearing, every potential question Morrison might ask, every angle Malcolm's team might use to attack. I read it twice, took notes, tried to sleep, and mostly failed. Monday morning, I met with Jennifer at the office at 7 a.m. We went through everything again, rehearsing my responses to hypothetical questions, making sure I understood not just what to say, but why I was saying it. "Remember," Jennifer said, Morrison isn't the enemy. She's strict, but she's fair. She wants to apply the law correctly. Our job is to show her that the law includes this administrative remedy, and that ignoring it would be a mistake. What if she's already made up her mind? Then we lose with dignity and immediately appeal. But I don't think she has. She denied the stay, but she also said she'd consider the board's decision if it comes in time. That's not the language of someone who's already decided we're wrong. At 8:30 a.m., Dorothy arrived. She wasn't wearing her cleaning uniform. Instead, she wore a simple navy dress and a cardigan, her gray hair pulled back neatly. She looked professional, dignified, like someone who'd spent decades in law offices, because that's exactly what she'd done. "Good morning," she said, setting down a worn leather briefcase that looked like it was older than I was. "I brought my original research files in case the judge wants to see them." Jennifer smiled. "Perfect. Dorothy, let's go over what might happen in there. I can't put you on the stand because you're not a sworn expert witness. But if the judge asks questions about the research, I can defer to you as a consultant on the case. Are you comfortable with that?" "I'm comfortable explaining something I've spent 3 decades understanding," Dorothy said simply. "Whether it's to a judge or to anyone else." We went over the plan one more time. Then we gathered our materials, loaded everything into Jennifer's car, and drove to the courthouse. The preliminary hearing was scheduled for 2 p.m. in Judge Morrison's courtroom. We arrived at 1:30 p.m. to find Malcolm's legal team already there. 6 lawyers in expensive suits, all looking exactly like what they were. Corporate litigators who charged $1,000 an hour and won most of their cases. They glanced at us with the kind of dismissive confidence that comes from knowing they have every advantage. More lawyers, more resources, more experience winning cases exactly like this one. But they didn't have Dorothy. And as we walked past them into the courtroom, as I saw Dorothy carrying her old briefcase with the same quiet dignity she brought to every task, I realized something. They'd already lost in one important way. They'd never looked past the uniform. They'd never bothered to see who was really standing in front of them. And that blindness, that arrogant certainty that the only people worth listening to were the ones who looked like lawyers, that was going to be their weakness. We just had to hope it would be enough. The bailiff announced Judge Morrison's entrance, and we all stood as she swept into the courtroom, a woman in her mid-50s with sharp eyes and an expression that gave away nothing. "Please be seated," she said, settling into her chair and looking down at the papers in front of her. "I've reviewed all the filings in this matter, including the petition filed Friday to the Charitable Assets Oversight Board and the subsequent responses. This is a preliminary hearing to determine whether there are grounds to proceed with the petitioner's request for dissolution of the Reeves Foundation based on alleged transfer irregularities." She looked up, her eyes moving from Malcolm's team to ours. "I'll hear from the petitioner first. Mr. Caldwell?" The lead lawyer for Malcolm's side stood up. His name was Gerald Caldwell, and according to Jennifer's research, he'd never lost a case involving charitable trust dissolution. He was about to tell the judge why we deserved to lose everything. And we were about to find out if a 62-year-old former paralegal's research could stand up against the full weight of corporate legal power. The fight was about to begin, and for the first time in months, I wasn't afraid. I was ready. Gerald Caldwell stood like a man who'd argued 100 cases exactly like this one, and won them all. Tall, silver-haired, with the kind of assured posture that comes from decades of being the smartest person in most rooms. His suit probably cost more than Dorothy made in 3 months. "Your Honor," he began, his voice smooth and confident, "this case is remarkably straightforward despite the respondent's recent attempts to complicate it. The law is clear. California Corporate Code Section 5142, subsection 7C, requires specific documentation to be filed within 60 days of a trust founder's death when assets are being transferred to a non-spouse heir. That filing did not occur. The deadline has passed by more than 4 months. Under established precedent, this failure renders the transfer incomplete and subjects the Foundation's assets to dissolution proceedings. He moved to a display board his team had set up, showing a timeline with the relevant dates highlighted in red. The visual was effective, simple, clean, damning. William Reeves died on April 4th of this year. The required form, CT-19, should have been filed by June 3rd. It was not. We are now at October 26th. There is no provision in the statute for late filing. There is no exception for good faith errors. There is no remedy for this failure. Caldwell turned back to face the judge, and I saw something flicker in his expression. Satisfaction. He thought he had this one already. The respondent has filed a petition with the Charitable Assets Oversight Board, claiming there exists some administrative remedy that can retroactively cure this fundamental filing failure. Your Honor, this is a distraction. The board's authority, to the extent it even applies here, which we strongly contest, cannot override explicit statutory deadlines. More importantly, once litigation is filed, administrative remedies become moot. This court has jurisdiction over the dissolution proceedings. The board does not. He paused for effect, looking at the papers in front of him. We've cited 17 cases in our opposition brief where courts have held that administrative processes cannot interfere with ongoing litigation. The respondent's petition is nothing more than a last-minute Hail Mary, an attempt to manufacture hope where none legally exists. We respectfully ask this court to find that the transfer was invalid, that the Foundation's assets are subject to dissolution, and that Mr. Caldwell. Judge Morrison interrupted, her voice sharp. I've read your brief, all 43 pages of it. I don't need you to recite it verbatim. What I need you to address is this. Are you arguing that the Charitable Assets Oversight Board has no authority whatsoever to review late filing petitions? Or are you arguing that their authority is somehow suspended because your client filed this lawsuit? Caldwell hesitated for just a fraction of a second. It was the first time I'd seen him look anything less than certain. We're arguing both. Your Honor, the board's purported authority to accept late filings is questionable at best, based on statutory language that hasn't been updated since 1947. But even if that authority exists in theory, it cannot be invoked to interfere with these proceedings. Once Mr. Malcolm filed his petition for dissolution, this became a matter for this court's jurisdiction exclusively. So, in your view, the act of filing a lawsuit eliminates any administrative remedy that might otherwise exist? In cases where the administrative remedy would directly contradict or undermine the litigation, yes, Your Honor. Morrison made a note on her legal pad. Interesting theory. I'll want to examine the cases you've cited more closely. Ms. Brooks, you're up. Jennifer stood, and I watched her transform. She was always professional, always competent, but something shifted in her when she was arguing. She became sharper, more focused, like a blade that had been honed for exactly this purpose. Your Honor, the respondent's position is built on a fundamental misunderstanding or perhaps a deliberate misrepresentation of how California charitable trust law operates. Yes, Form CT-19 should have been filed within 60 days. Yes, that deadline was missed. But Mr. Caldwell's claim that there is no remedy is simply false. She moved to our table and picked up a thick binder. The Charitable Assets Oversight Board was created in 1947 by the same legislation that established the Form CT-19 requirement. This wasn't a coincidence. The legislature understood that technical filing requirements might be missed in good faith, and they built in a safety valve, a board with explicit discretionary authority to review late filing petitions and, where appropriate, to accept them. Jennifer opened the binder and pulled out a document, handing copies to the judge and to Caldwell. This is the original legislative history from Assembly Bill 2847, passed in 1947. I'd like to direct Your Honor's attention to page 12, section 4, where Assemblyman Robert Hutchins explained the purpose of creating the Oversight Board. I'll read the relevant portion. We recognize that charitable organizations serve vital public interests, and that their dissolution over mere technical violations would harm the very communities these organizations serve. Therefore, this bill establishes a review board with authority to evaluate late compliance in cases where the charitable mission has been maintained, and the failure to file was not willful or fraudulent. Morrison was reading the document, her expression neutral but attentive. Caldwell was reading too, and I saw something tighten around his eyes. He hadn't expected this level of historical documentation. The board has exercised this authority 7 times between 1952 and 1994, Jennifer continued. In every single case where a petitioner met the 3 statutory criteria, substantial compliance with intent, non-willful delay, and continuous charitable operation, the board accepted the late filing. Not most of the time, not usually, every single time. She pulled out another document. This is our petition to the board, filed last Friday. It demonstrates, with extensive documentation, that the Reeves Foundation meets all 3 criteria. Since Jackson Reeves assumed control 6 months ago, the foundation has expanded operations in 3 cities, taken on 147 new cases, and provided legal assistance to over 800 individuals who could not afford representation. The filing failure was clearly not willful. Mr. Reeves's father's attorneys believed they had filed all necessary documentation. And substantial compliance is evident in the Foundation's continued mission-driven work. Morrison looked up. Ms. Brooks, I understand your argument about the board's authority. What I'm less clear on is how this affects my jurisdiction. Mr. Caldwell makes a valid point. Once litigation is filed, don't I have primary jurisdiction over these matters? This was the critical moment. Jennifer had prepared me for this question. She took a breath. Your Honor, with respect, that's not quite accurate. You have jurisdiction over Mr. Malcolm's petition for dissolution, but the Charitable Assets Oversight Board has jurisdiction over whether the transfer was properly completed. These are separate questions that happen to intersect in this case. That seems like splitting hairs, counsel. I watched Morrison process this. She was silent for a long moment, her pen tapping against her legal pad in a steady rhythm. Mr. Caldwell, response? Caldwell stood again, and I could see the wheels turning behind his eyes. He was recalculating, adjusting his strategy in real time. Your Honor, Ms. Brooks's analogy is flawed. A corrected deed doesn't retroactively change. When the deed was filed, it corrects errors in the existing filing. What the respondent is asking for is fundamentally different. They want an administrative board to erase a deadline that has long since passed. That's not correction. That's time travel. A few people in the courtroom chuckled softly. Caldwell smiled, pleased with his own rhetoric. Moreover, he continued, even if we accept that the board has theoretical authority to consider late filings, there's no precedent for invoking that authority once litigation has commenced. The cases Ms. Brooks cited all involved administrative reviews that happened before any lawsuit was filed. This is different. Mr. Malcolm has already filed his petition, discovery has been conducted, and we are now at the preliminary hearing stage. Allowing an administrative board to potentially upend these proceedings at this late stage would create chaos. Morrison nodded slowly. That's a fair point, Ms. Brooks. Jennifer didn't hesitate. Your Honor, the timing of Mr. Malcolm's lawsuit doesn't negate the board's statutory authority. If Mr. Malcolm had filed his petition a year from now, would Mr. Caldwell argue that the board lost its authority to review late filings simply because more time had passed? The board's jurisdiction exists independently of this litigation, and respectfully, there's no chaos in pausing these proceedings for 30 days to allow the board to complete its statutorily mandated review. I denied your motion for a stay, Morrison reminded her. You did, Your Honor. But you also indicated in your written order that you would consider the board's decision if it comes before you render a final ruling. We're simply asking you to give the board the time to complete that review. They meet this Thursday. They'll issue a decision within 2 weeks. That's not an unreasonable delay. Morrison leaned back in her chair, studying both lawyers. The courtroom was silent, except for the soft hum of the ventilation system and the occasional shuffle of papers. "I'll be honest with both of you," the judge said finally. "This is a closer question than either side is making it out to be. Mr. Caldwell, your argument that litigation supersedes administrative remedies is not as clearly established as you suggest. And Ms. Brooks, your position that the board can essentially override a statutory deadline is not without problems either." She looked down at her notes again. "Ms. Brooks, you mentioned that your research on this issue came from someone with particular expertise in this area of law. I'd like to hear more about that. Who did this research?" Jennifer glanced back at our table. At Dorothy, who was sitting quietly in the second row, her hands folded over her old briefcase. "Your Honor, the foundational research was conducted by Dorothy Walsh, a former paralegal who specialized in charitable trust law and who has been studying this particular statute for over 27 years. Caldwell made a sound that might have been a scoff. "A former paralegal?" Morrison's eyes sharpened. "Mr. Caldwell, in my courtroom, we judge arguments by their merit, not by the credentials of the person who made them. Ms. Brooks, is Ms. Walsh present?" "She is, Your Honor." "I'd like to speak with her. Ms. Walsh, would you approach the bench, please?" Dorothy stood slowly, picking up her briefcase. I saw Caldwell exchange a glance with one of his associates, a look that clearly said, "They're bringing a janitor to argue charitable trust law." The arrogance in that glance made something hot and sharp rise in my chest. But Dorothy didn't look nervous. She walked to the bench with the same quiet dignity she brought to everything, set her briefcase down on the counsel table, and looked up at Judge Morrison. "Ms. Walsh," Morrison said, her tone neutral but not unkind, "Ms. Brooks says you've been researching Section 5142 for 27 years. That's a long time to focus on a single statute. Why?" Dorothy didn't pause to gather her thoughts or look to Jennifer for guidance. She just answered, clear and direct. "Because in 1995, Your Honor, I worked on a case involving this exact issue, the Henderson Foundation. We lost, and I watched a charitable organization that was doing genuine good work get dissolved over a filing technicality. It bothered me, so I kept researching, trying to understand if there had been a way to save it that we'd missed." "And you found one?" "I found that the statute we were fighting against also contained its own remedy. The legislature that created the filing requirement also created a board specifically to handle good faith failures to meet that requirement. We didn't know about it in 1995 because the connection between the filing requirement and the board's remedial authority wasn't obvious unless you went back to the original legislative materials." Morrison was watching Dorothy carefully. "You're no longer a paralegal?" "No, Your Honor. Life circumstances changed, and I took other work. But I never stopped being interested in the law, and I never threw away my research." "Why not?" Dorothy smiled slightly. "Because I believed that someday it might matter. That someday there might be another foundation facing the same situation, and maybe this time the information could help instead of arrive too late." The courtroom was very quiet. Morrison glanced down at the petition Jennifer had filed, then back at Dorothy. "Ms. Walsh, I'm going to ask you a direct question, and I want your honest assessment, not what you think I want to hear. In your expert opinion, and yes, I'm calling it expert opinion, because 27 years of focused research qualifies, does the Charitable Assets Oversight Board have clear statutory authority to accept late filings in cases like this one?" Dorothy didn't hesitate. "Yes, Your Honor. Absolutely. The authority is explicit in the original enabling statute and has never been repealed or modified. The board was created for exactly this purpose. And do you believe the Reeves Foundation meets the criteria for acceptance? I do. The filing failure was clearly not willful. Mr. Reeves's father's attorneys made a good-faith mistake. The foundation has continued operating consistently with its charitable mission, and there's substantial compliance with the statute's intent, which was to ensure proper oversight of charitable assets. All three criteria are met. Morrison made another note. Then she looked at Caldwell. Mr. Caldwell, you've been very quiet. Do you have any questions for Ms. Walsh? Caldwell stood, and I saw the calculation in his eyes. He could attack Dorothy's credentials, question her expertise, try to diminish her in front of the judge. But Morrison had just called her an expert. Attacking her now might backfire. Ms. Walsh, he said carefully, you said this board has accepted late filing petitions 7 times. How many times has it denied such petitions? I found no record of any denials in cases that met the 3 criteria, Dorothy said. There may have been petitions that were denied because they didn't meet the criteria, but I couldn't find records of those. The 7 I found all resulted in acceptance. So you're basing your opinion on 7 cases spanning 42 years. That's not exactly a robust data set. It's the complete data set of recorded decisions involving this specific issue, Dorothy replied calmly. The reason there aren't more cases is that most attorneys don't know this remedy exists. But when it has been invoked properly, it has succeeded every time. Caldwell shifted tactics. How do you know those cases involved situations similar to this one? Maybe they all had different circumstances that made them easier calls. Dorothy opened her briefcase and pulled out a folder. I have summaries of all 7 cases right here, Mr. Caldwell. Would you like me to walk you through them? Case by case, showing how each one involved a missed filing deadline, a good-faith mistake, and a foundation that was actively serving its mission? Caldwell's jaw tightened. He'd just been offered a detailed breakdown he probably didn't want, delivered by someone who clearly knew every detail of every case. That won't be necessary, he said. Your Honor, regardless of Ms. Walsh's research, the fundamental issue remains. This board's authority cannot supersede this court's jurisdiction over pending litigation. Morrison held up a hand. Mr. Caldwell, you keep returning to that argument, and I keep finding it less persuasive. The board isn't superseding my jurisdiction. It's exercising its own independent statutory authority. If anything, failing to allow the board to complete its review might constitute judicial overreach into an administrative function. I saw Caldwell's expression shift. He was losing ground, and he knew it. Morrison looked at both legal teams. Here's what I'm going to do. This preliminary hearing was scheduled to determine whether to proceed with dissolution proceedings. Having heard arguments from both sides and having reviewed the extensive documentation provided, I find that there are substantial questions that need to be resolved before I can make an informed ruling. She picked up her gavel. I am issuing a 90-day continuance of these proceedings. During that time, the Charitable Assets Oversight Board will review the petition filed by the Reeves Foundation. If the board accepts the late filing, Mr. Malcolm's case will be moot. If the board denies the petition, we'll reconvene and address Mr. Malcolm's dissolution request. Either way, we'll have a complete record to work from. Caldwell stood quickly. Your Honor, a 90-day delay is well within my discretionary authority to manage my own calendar, Mr. Caldwell. I've made my decision. This hearing is continued until January 24th. In the meantime, the Reeves Foundation will continue operating under its current structure, and no dissolution proceedings will move forward. She struck the gavel once, and the sound echoed through the courtroom like a bell. We're adjourned. For a moment, nobody moved. Then Morrison stood, and we all rose automatically as she exited to her chambers. The second the door closed behind her, Jennifer grabbed my arm. We won, she said quietly. Jackson, we actually won. We got a continuance, I corrected, but I was smiling. Actually smiling for the first time in months. It's not over. It's not over, but we're not dead. That's huge! I turned to Dorothy, who was carefully packing her folder back into her briefcase. She looked up when she felt my eyes on her. You did that, I said. Morrison listened because of you. Morrison listened because the law is on our side, Dorothy corrected gently. I just helped you find it. Across the aisle, Malcolm's legal team was packing up with the kind of tight-lipped efficiency that comes from losing an argument you expected to win. Caldwell caught my eye, and the look he gave me was cold. This isn't over, Mr. Reeves, he said. You've bought yourself 3 months, but the board still has to accept your petition. And if they don't, then we'll be right back here, I finished. I'm aware. Seth Malcolm doesn't lose. Then this will be a learning experience for him. Caldwell's eyes narrowed, but he didn't respond. He just gathered his things and walked out, his team following like a corporate funeral procession. When they were gone, Jennifer let out a breath that sounded like she'd been holding it for hours. Okay, she said. Okay, we need to prepare for the board meeting on Thursday. That's in 3 days. We need to make sure our petition is airtight, that we've anticipated every question they might ask. That, Jennifer, Dorothy interrupted gently. The petition is airtight. We made sure of that. What you need now is to go home, have a glass of wine, and get a full night's sleep. All 3 of you. She looked at me, at Jennifer, then smiled. You've been running on fumes and fear for months. You've got 3 days before the board meets, and you've done the work. Use those 3 days to remember why this matters. Spend time with the people the foundation helps. Visit the legal firms. Talk to the clients. Remember what you're fighting for, so when you walk into that board meeting, it's not about legal technicalities. It's about people. Jennifer nodded slowly. That's actually good advice. I've been at this a long time, Dorothy said. You learn a few things. We walked out of the courthouse together, into the late afternoon sun that felt warmer than it had any right to feel in late October. The air was crisp and clear, and for the first time since my father died, I felt like I could breathe properly. We weren't saved yet. The board still had to accept our petition. They could deny it. They could find some reason that our situation was different from those 7 historical cases. They could decide that Morrison's continuance didn't matter, because they weren't going to help us anyway. But we had a chance. A real, legitimate, documented in 27 years of research chance. And as we stood on the courthouse steps, Dorothy Walsh in her navy dress and cardigan, Jennifer Brooks with her legal files under her arm, and me with my father's foundation, hanging in the balance, I realized something important. Sometimes the people who save you aren't the ones you expect. Sometimes they're the ones everyone else overlooked. And sometimes, if you're very lucky, they've been preparing to save you for 27 years without even knowing it. The thing about fighting for an organization is that you can lose sight of what that organization actually does. For 4 months, I'd been drowning in legal documents, court filings, strategy sessions with lawyers who charged by the 6-minute increment. The foundation had become an abstract concept, a thing to be saved, a legacy to be protected, a $300 million entity that existed primarily on paper. Dorothy was right. I needed to remember what we were actually fighting for. So Tuesday morning, instead of going to the office, I drove to South Central Los Angeles, to one of the legal aid firms the foundation funded. It was housed in a converted storefront between a laundromat and a bodega, the kind of place that would be easy to miss if you weren't looking for it. A faded sign above the door read, Reeves Foundation Legal Services, in letters that had seen better days. Inside, the waiting room was full. A young mother with 2 kids clinging to her legs. An elderly man with papers clutched in weathered hands. A teenager who couldn't have been more than 16, sitting alone and trying to look tougher than he probably felt. All of them waiting to see one of the 3 attorneys who staffed this firm on foundation grants. The receptionist looked up when I walked in. Her name was Maria, and she'd been with the firm for 8 years. She recognized me immediately. "Mr. Reeves," she said, surprise evident in her voice, "we weren't expecting you today." "I should visit more often," I said. "I've been dealing with some things, but I wanted to see how everything's running here." Maria's expression shifted to something more guarded. "We heard about the lawsuit. The whole staff has heard. Is it true? Could the firm really close?" Everyone in the waiting room had stopped their quiet conversations. They were all looking at me now, waiting for an answer. I could have lied, could have given them some bland reassurance that everything was fine, nothing to worry about. But these were people who'd been lied to enough by enough people in power. They deserved better. "There's a lawsuit," I said. "Someone's trying to take control of the foundation and shut down the work we do. But we're fighting it. And as of yesterday, we've got a real chance to win. The firms aren't closing. Not if I have anything to say about it." The young mother spoke up, her voice carrying an edge of desperation. "What happens if you lose? What happens to people like us?" "You find other help," I said honestly. "There are other organizations, other resources. But I know they're already stretched thin, already turning people away because they don't have enough staff or funding. That's why my father built this foundation, because there wasn't enough help to go around." I looked at each person in that waiting room. I'm not going to lie to you and say everything's guaranteed to be okay. But I am going to tell you that we're fighting as hard as we possibly can. And we're not giving up. The elderly man with the papers cleared his throat. "Your father helped me once," he said quietly. 10 years ago, my landlord was trying to evict me illegally. Wanted to rent my apartment to someone who'd pay more. I couldn't afford a lawyer. Your father's foundation sent someone who fought for me. I'm still in that apartment." He stood up slowly, walked over to me, and shook my hand with a grip that was surprisingly strong. "You fight for this place," he said. "You hear me? You fight because there's people who need it. People like me who can't fight for themselves." My throat was tight. "I'm fighting! I promise you that." Maria gestured to the hallway behind her desk. "The attorneys are in consultations right now, but I know they'd want to see you. Especially Amanda. She's been worried about whether there'll be funding for next quarter. Can I wait? Sit in on a consultation if the client agrees. Let me ask." Maria disappeared down the hallway and returned a few minutes later with a woman in her late 20s, wearing jeans and a blazer that had seen better days. Amanda Torres, one of the youngest attorneys on staff and, according to Jennifer, one of the most dedicated. "Jackson," Amanda said, offering a tired smile. "This is a surprise. Good timing, actually. I've got a client who might benefit from hearing that the foundation isn't going anywhere. She's terrified about what happens if we have to close her case. Can I meet her? If she's okay with it. Let me ask." 5 minutes later, I was sitting in a small conference room across from a woman named Teresa Morales. She was 43, according to the file Amanda had briefly shown me, and she looked like someone who'd been running on fear and exhaustion for a very long time. "Ms. Morales," Amanda said gently, "this is Jackson Reeves. His father founded this firm. I thought he should hear your story." Teresa looked at me with eyes that had seen too much. "Why? So he can feel good about the charity work?" The words stung, but they were fair. How many times had wealthy people toured organizations they funded, treating real people's suffering like it was a museum exhibit? "No," I said. "So I can remember why I'm fighting so hard to keep this place open. So when I'm sitting in meetings with lawyers and judges, I remember that you're not a case file or a statistic. You're a person who needs help." Teresa studied my face for a long moment. Then she nodded slowly. "My husband died 3 years ago," she said. "Left me with 2 kids and a house that still had 20 years on the mortgage. I worked 2 jobs cleaning offices during the day, stocking shelves at night. I thought I could manage. But then the mortgage company sold my loan to another company, and that company said I'd missed payments I know I made. They say I'm 4 months behind. They're foreclosing!" She pulled out a stack of papers, foreclosure notices, payment records, certified mail receipts. I have proof I paid. I have bank statements showing the money came out of my account. But they say their records show something different. And unless I can come up with $16,000 in back payments by next month, I lose my house. I lose the only thing my kids have left of their father." Amanda leaned forward. "We've been fighting the foreclosure, and we've found discrepancies in their records. We think we can prove the payments were misapplied. But it takes time, and the foreclosure process moves fast. We need another 3 months to build the case properly." "And if the firm closes?" Teresa asked, looking at me. "Then I'd have to stop working her case," Amanda said quietly. "And Teresa would need to find another attorney, which she can't afford. Or she could try to represent herself, which against a major mortgage servicer would be impossible," Teresa finished. "I know. I've tried reading the legal documents. I don't understand half of what they say." She looked at me with something that wasn't quite anger but was close to it. "You want to know why you're fighting? This is why. Because people like me can't fight companies that have entire legal departments. We can't afford lawyers who charge $300 an hour. We need places like this. We need people who'll fight for us even though we can't pay them." I thought about Seth Malcolm, about his army of lawyers, and his desire to destroy the foundation out of spite, about how much money he'd already spent trying to win this case money that could have funded this firm for years. "We're going to win," I said. "The case, the foundation, all of it. You're going to keep your house, Teresa. Amanda's going to have the time she needs to prove those payments were made. And this firm is going to stay open." "You can't promise that," Teresa said. But there was hope in her voice, fragile and cautious. "You're right. I can't promise it. But I can promise I'm going to do everything in my power to make it happen." I spent the rest of the day at that firm, met with 6 more clients, listened to 6 more stories of people who'd been chewed up by systems designed to favor the powerful. A construction worker injured on the job, whose employer was denying workers' compensation. A family facing deportation despite having legal status because of a paperwork error. A young woman trying to escape an abusive relationship while fighting for custody of her daughter. Each story was different. Each one was a reminder that the foundation wasn't just an abstract concept or a legal entity to be protected. It was the difference between justice and injustice for people who had no other options. By the time I left the firm at 6 p.m., I was exhausted. But it was a different kind of exhaustion than what I'd been feeling for months. This wasn't the hollow, despairing exhaustion of fighting a losing battle. This was the bone-deep weariness that comes from doing something that matters. My phone had 17 missed calls. Most were from the office, from staff checking in. But one was from Dorothy, and her voicemail was simple. "Jackson, I hope you took my advice today. Remember why it matters. I'll see you Thursday at the board meeting." I drove home through rush hour traffic, thinking about Teresa and the elderly man and the teenager in the waiting room. Thinking about Amanda Torres, who'd turned down 6-figure salaries to make $38,000 a year fighting for people who couldn't fight for themselves. My father had seen all of this, had lived this every day of his career. And he'd decided it wasn't enough to just be one lawyer helping one person at a time. He'd wanted to build something bigger, something that could help hundreds or thousands of people. And now that something was in danger because he died before a piece of paper got filed, the unfairness of it burned in my chest. But underneath the anger was something stronger. Determination. Because Teresa was right. People like her needed places like our firms. They needed advocates who'd stand up to the powerful and fight for what was right. My phone rang as I pulled into my apartment complex. "Jennifer, tell me you spent today doing something other than obsessing about Thursday's board meeting," she said when I answered. "I went to the South Central firm. Met some of the clients. Good. Dorothy was right, you needed that. I heard papers shuffling in the background. I've been prepping for Thursday, going through every possible question the board might ask, every angle they might come at this from. I think we're ready. What if we're not? What if they deny the petition? Jennifer was quiet for a moment. Then we appeal their decision. There's a review process. It'll take time, and Malcolm will push for Morrison to rule before the appeal is resolved. But we'll fight that. We've got options, Jackson. They're not great options, but they exist. And if we lose all of it? If Morrison rules against us, and the board denies us, and the appeals go nowhere, then we'll have tried everything possible. And we'll know we fought for something that mattered. She paused. Did meeting those clients today change anything for you? I thought about Teresa's face when she'd asked if we could promise her she'd keep her house. About the elderly man who'd shaken my hand and told me to fight. About the waiting. Room full of people who'd been let down by every other system they'd encountered. Yeah, I said, it reminded me that this isn't about my father's legacy, or my inheritance, or protecting what's mine. It's about those people. They're why it matters. Good. Hold on to that feeling for Thursday. The board members aren't going to care about legal technicalities or statutory interpretation. They're going to care about whether the foundation is actually serving the public good, and whether shutting it down over a filing mistake serves justice. We talked for a few more minutes about logistics, what time we'd meet, what materials we'd bring, who would speak during the presentation. When we hung up, I sat in my car for a long moment, looking up at my apartment building. Somewhere in Sacramento, 5 board members were probably reviewing our petition, reading through the 32 pages of arguments and evidence that Dorothy and Jennifer had crafted, making up their minds about whether a filing deadline that had passed 4 months ago could be forgiven. 5 people I'd never met held the fate of the foundation in their hands. 5 people who would decide whether Teresa kept her house, whether Amanda kept her job, whether hundreds of people waiting in firms across 12 cities would continue to have access to justice. It should have terrified me. And maybe it did, a little. But mostly I felt something else. Trust. Trust that Dorothy's research was solid. Trust that Jennifer's legal arguments were sound. Trust that the board members, whoever they were, would see what we saw, that punishing hundreds of innocent people for a lawyer's good faith mistake didn't serve justice. And if they didn't see it, if they denied our petition and sent us back to face Judge Morrison with nothing left to argue, then we'd cross that bridge when we came to it. Wednesday passed in a strange blur of preparation and forced calm. I went to the office, but found it impossible to focus on normal work. Jennifer called twice with minor updates. She'd refined one section of the oral argument. Dorothy had found one additional case citation that might be helpful. Around 3 p.m., my assistant knocked on my door. "There's someone here to see you. She doesn't have an appointment, but she says it's important. Her name is Dorothy Walsh." I stood immediately. "Send her in." Dorothy entered, wearing her cleaning uniform. She must have come straight from a shift. She looked tired but determined, and she was carrying that same worn leather briefcase. "I'm sorry to drop in unannounced," she said, "but I wanted to give you something before tomorrow." She set the briefcase on my desk and opened it, pulling out a folder I hadn't seen before. When she handed it to me, I saw it was labeled Henderson Foundation Final Arguments, November 1995. "This is from the case you lost," I said. "It is. I've kept it all these years as a reminder." Dorothy sat down without being invited, the way she had that first night. "I want you to read the closing statement our attorney made. Read what he argued and how he argued it. And then I want you to make sure we don't make the same mistakes tomorrow." I opened the folder. Inside was a transcript of a court hearing, yellowed with age but still readable. I skimmed through it, seeing arguments about statutory obsolescence, procedural technicalities, equitable considerations. He argued around the problem, I said slowly. He never addressed it head-on. Exactly. Dorothy leaned forward. He was so focused on finding loopholes and workarounds that he never made the simple, direct argument that the board existed to fix exactly this kind of problem, and that it should be allowed to do its job. He got tangled up in legal complexities when the answer was straightforward. Why? Because he was trying to be clever, trying to find the brilliant legal maneuver that would wow the judge. But sometimes, most of the time, really, the straightforward truth is more powerful than the clever argument. I looked at the transcript again, seeing it differently now, seeing all the places where the attorney had zigged when he should have zagged, complicated things that should have been simple, obscured the core issue under layers of legal reasoning. Tomorrow, Dorothy said, when we walk into that board meeting, we're not going to be clever. We're going to be clear. We're going to tell them the truth. Your father's lawyers made a good-faith mistake. The foundation has been operating exactly as intended, and dissolving it over a filing technicality would harm hundreds of people while serving no legitimate purpose. That's it. That's the whole argument. What if they want more? What if they dig into the legal minutiae and then we'll have the minutiae ready? But we lead with the truth. Dorothy stood, picking up her briefcase. Jackson, I've been thinking about this case for 27 years. I've imagined this moment, the moment when I might actually help save a foundation instead of watching it die. And I've realized something. I was so focused on the legal research, on finding the perfect citations and precedents, that I almost forgot the most important thing. What's that? That justice isn't really about statutes and regulations. It's about people. It's about doing what's right, even when it's not convenient. The board members aren't lawyers. They're administrators appointed to make sure charitable assets serve the public good. They don't need to be impressed by our legal brilliance. They need to understand that approving our petition serves justice, and denying it doesn't. She moved toward the door, then paused. Your father understood that. He could have been a partner at some big firm, making millions. But he spent his career in courtrooms fighting for people who couldn't afford to fight for themselves. Not because it was legally interesting, but because it was right. Tomorrow, when you tell the board why they should approve our petition, channel that. Channel him. After she left, I sat alone in my office reading and rereading that transcript from 1995, seeing all the ways that attorney had failed the Henderson Foundation. Learning from mistakes made nearly 30 years ago so I wouldn't repeat them tomorrow. Around 6 p.m., I called Riley. Big day tomorrow, she said by way of greeting. Big day, I agreed. I wanted to hear your voice. Tell me something normal, something that has nothing to do with lawsuits or foundations or filing deadlines. So Riley told me about her anatomy practical, about the study group she'd joined, about the terrible coffee in the medical school library. Normal things. Simple things. The kind of conversation we used to have before my father died, and everything became complicated. When we hung up, I felt steadier, more centered. I went home, made dinner, and tried to sleep. Mostly failed. But at some point in the early morning hours, I drifted off thinking about Teresa Morales and her house, about the elderly man still living in his apartment 10 years after my father's foundation saved him from eviction, about Amanda Torres working 2 jobs' worth of hours for 1 job's pay because she believed in what we did. When my alarm went off at 6 a.m. Thursday morning, I woke up not afraid, but ready. Today was the day. Today, 5 strangers in Sacramento would decide the fate of everything my father had built. And all we could do was tell them the truth and hope it was enough. The California Charitable Assets Oversight. Board met in a conference room that looked like it had been designed by the same person who designed the building's exterior functional, bland, and determinedly uninspiring. Gray carpet, beige walls, a long table with chairs that had seen better decades. The only decoration was a framed copy of the California State Seal and a portrait of the current governor that was already 3 years out of date. We arrived at 8:30 for a 9 o'clock hearing. Jennifer, Dorothy, and me, plus 2 bankers, boxes full of documentation that we probably wouldn't need, but brought anyway because being overprepared felt better than the alternative. The board's clerk, a woman in her 50s with reading glasses on a chain around her neck, checked us in with bureaucratic efficiency. "You're on the agenda for 9:15, she said, handing Jennifer a packet of papers. "These are the board members' preliminary questions. You'll have 30 minutes to present your case, followed by a question-and-answer session of undetermined length. The board will deliberate in closed session and issue their decision within 14 business days." 14 days, I said. I thought decisions usually came faster. The clerk looked at me with the expression of someone who'd explained this 1,000 times. "The board reviews complex charitable trust matters. They take the time necessary to reach considered decisions. 14 days is standard. Sometimes it's longer." Jennifer thanked her, and we found seats in the small waiting area outside the conference room. Through the glass door, I could see 5 people taking their seats around the table, the board members who held our future in their hands. "Tell me about them," I said quietly to Jennifer. "Who are we dealing with?" Jennifer pulled out her phone where she'd compiled profiles on each board member. Chair is Dr. Patricia Hammond, retired economics professor from UC Berkeley. She's been on the board for 12 years, known for being thorough and slightly impatient with poorly prepared presenters. Next is Robert Fitzgerald, former state controller, very by the book, focused on regulatory compliance. Then there's Grace Liu. She's a community organizer who was appointed 3 years ago to bring a non-governmental perspective. Miguel Santos, he's an attorney who specializes in nonprofit law. And finally, David Brenner, he's a CPA who's spent his career auditing charitable organizations. So we've got an economist, a bureaucrat, a community advocate, a nonprofit lawyer, and an accountant. Exactly. They're supposed to represent different perspectives on charitable asset management. In theory, it creates balanced decision-making. In practice, Jennifer shrugged, they don't always agree with each other, which can make their deliberations unpredictable. Dorothy had been quiet, but now she spoke up. "Grace Liu is the one to focus on." We both looked at her. "Why?" I asked. "Because she's not a lawyer or a regulator. She's there to represent the community perspective, to make sure the board isn't just enforcing technical rules, but actually considering the impact on real people. If we can make her understand what losing this foundation would mean to communities like South Central LA, she'll be our strongest advocate in deliberations." "How do you know that?" Jennifer asked. Dorothy smiled slightly. "Because I read the minutes from the last 2 years of board meetings. Liu is always the one asking, 'What about the people who will be affected by this decision?' Us, she's pushed back on several cases where the other board members wanted to approve dissolutions of organizations that were technically non-compliant but still serving important functions." Jennifer stared at Dorothy. "You read 2 years of board meeting minutes?" "I had time," Dorothy said simply. "And I wanted to know who we'd be talking to." The clerk appeared at the door. "The board is ready for you." My heart kicked into a higher gear. This was it. 30 minutes to convince 5 strangers that a filing mistake shouldn't destroy everything my father had built. We gathered our materials and walked into the conference room. The board members looked up as we entered 5 faces, ranging from politely interested to mildly skeptical. Dr. Hammond, sitting at the center position, gestured to 3 chairs facing the table. "Mr. Reeves, Ms. Brooks, Ms. Walsh, please be seated." Before we begin, I want to clarify the scope of today's hearing. We've reviewed your petition and the supporting documentation. Our questions will focus on three areas: the circumstances surrounding the filing failure, the Foundation's current operations and charitable impact, and your interpretation of this board's remedial authority. Do you have any procedural questions before we start? No, Your Honor. I started, then caught myself. I'm sorry, Dr. Hammond. No procedural questions. A slight smile crossed Hammond's face. Easy mistake. We're not a court, Mr. Reeves, though we sometimes feel like one. Please proceed with your opening statement. Jennifer had offered to handle this part, but we'd agreed that I should speak first. That the board should hear directly from the person who was actually running the foundation, not just from the lawyer representing it. I stood, took a breath, and began. 6 months ago, my father died in a courtroom defending a single mother who'd been falsely accused of theft. He was 63 years old. He had a heart attack while giving his closing argument, and his last words were asking the jury to find his client not guilty. I paused, letting that sink in. They did, by the way. Unanimous verdict in less than an hour. I saw Grace Lou lean forward slightly, her expression shifting from neutral to attentive. My father spent 40 years as a public defender and civil rights attorney. He watched thousands of innocent people go to prison or lose everything they owned because they couldn't afford proper legal representation. So he did something about it. He invested carefully, saved aggressively, and built the Reeves Foundation, a $300 million endowment dedicated to one mission: providing legal defense to people who can't afford it. I gestured to the documentation in front of them. Since my father's death, I've been managing that mission. We've expanded operations in 3 cities. We've taken on 147 new cases. We've provided legal assistance to over 800 people who had nowhere else to turn. People like Teresa Morales, a widow with 2 kids who's about to lose her house because a mortgage company misapplied her payments. People like James Miller, an 80-year-old veteran facing illegal eviction. People like Amanda Torres, a young attorney who turned down partnership track positions to make $38,000 a year defending people who can't defend themselves. Robert Fitzgerald, the former state controller, spoke up. Mr. Reeves, we're all sympathetic to your foundation's mission, but we're here to discuss a filing failure, not the merits of your charitable work. With respect, Mr. Fitzgerald, they're the same thing. I kept my voice steady but firm, because the filing failure is a technicality, a mistake made by my father's attorneys who believed they'd submitted all required documentation. But the impact of that mistake, if we can't cure it, affects hundreds of real people who depend on the foundation's work. Dr. Hammond made a note. Walk us through what happened. How did this filing failure occur? Jennifer stood and I sat down. This was her territory, the technical explanation of what had gone wrong. Dr. Hammond, when William Reeves died, his estate attorneys filed 17 different forms with various state and federal agencies. They were meticulous in their compliance review. But Form CT-19, which requires filing under California Corporate Code, Section 5142, subsection 7C, wasn't on any modern compliance checklist. The statute dates to 1947, and most legal databases treat it as obsolete because subsequent reforms created alternative filing pathways. She pulled out a document. This is the checklist the estate attorneys used. You'll see it was sourced from 3 different major legal compliance databases. None of them include Form CT-19. The attorneys did everything they reasonably could to ensure proper filing. They simply didn't know about a requirement that's been effectively invisible for decades. Miguel Santos, the nonprofit attorney, spoke next. Ms. Brooks, I've practiced in this field for 20 years, and I'd never heard of Form CT-19 until I read your petition. That suggests either you've uncovered something genuinely obscure or you've misinterpreted an obsolete statute. Which is it? It's genuinely obscure, Dorothy said, speaking for the first time. And that's exactly why this board exists. All 5 board members turned their attention to her. Dr. Hammond consulted her notes. Ms. Walsh, our preliminary questions indicated that you conducted the primary research on this statute. Can you explain your methodology? Dorothy opened her briefcase, that same worn leather case she'd brought to my office that first night, and pulled out a folder. In 1995, I worked as a paralegal on a case involving this exact statute. The Henderson Foundation case. We lost because we didn't know about this board's remedial authority. After that loss, I spent 3 years researching everything I could find about Section 5142 and the Charitable Assets Oversight Board. I read original legislative histories, committee reports, administrative decisions that were never published in mainstream databases. I became an expert in a piece of law that most people don't even know exists. She slid several documents across the table. These are the 7 previous cases where this board accepted late filing petitions. The earliest is from 1952, the most recent from 1994. In every case, the board determined that when a filing failure was not willful, when the charitable mission was being actively maintained, and when there was substantial compliance with the statute's intent, accepting a late filing served the public interest better than forcing dissolution. Grace Liu picked up one of the documents. Ms. Walsh, you said you spent 3 years on this research after losing a case. That's an unusual level of dedication for someone who was just a paralegal on the matter. Dorothy met her eyes. It wasn't unusual for me. I watched a charitable organization die because we didn't know enough to save it. That failure haunted me. So I made sure that if I ever encountered this situation again, I'd have the knowledge to help instead of standing by helplessly. And 27 years later, you encountered it again, Lou said softly. I did. Because I never stopped cleaning offices at night, and one of those offices belonged to Jackson Reeves. I saw him drowning in legal documents, watched him hire lawyer after lawyer who kept telling him there was no hope, and I recognized the statute they were fighting. I knew there was a remedy they didn't know about. David Brenner, the CPA, had been reviewing the financial documentation we'd provided. Now he looked up. Mr. Reeves, I've examined the Foundation's financial statements and operational records. You've actually increased spending on charitable programs since assuming control. Most new inheritors of large foundations spend the first year doing cautious reviews and maintaining status quo operations. Why did you expand? I stood again. Because my father didn't build this foundation to sit on a pile of money. He built it to help people. When I looked at the applications, we were turning away qualified cases where we simply didn't have enough attorneys to take them on. I couldn't accept that. So I hired 3 more staff attorneys, opened a new firm in Oakland, and increased our case acceptance rate by 22%. That's aggressive growth for someone facing a legal challenge to your control of the foundation. Brenner said, maybe, but those 147 new cases represent 147 people who needed help. I wasn't going to make them wait while I fought a legal battle. They needed help now. Dr. Hammond had been making notes throughout this exchange. Now she set down her pen and looked at each of us in turn. Let me address the elephant in the room. We have discretionary authority to accept late filings under the circumstances Ms. Walsh described. That authority is real and has been exercised before. But she held up a hand as I started to speak. We also have to consider whether exercising that authority in this case is appropriate. Mr. Caldwell, representing Seth Malcolm, filed a brief arguing that once litigation is initiated, administrative remedies become moot, that we'd be interfering with judicial proceedings. Jennifer stood immediately. Dr. Hammond, with respect, that argument misunderstands both this board's authority and the court's. Judge Morrison issued a 90-day continuance specifically to allow this board to complete its review. She explicitly stated that your decision would inform her ruling. Far from interfering with judicial proceedings, you'd be providing the court with crucial information it needs to render a proper decision. Robert Fitzgerald frowned. But if we accept this late filing, we're essentially overriding a statutory deadline that has passed by 4 months. That sets a precedent that filing deadlines are flexible, which undermines the entire compliance framework. No, Dorothy said firmly. You're not overriding anything. The legislature that created the filing deadline also created this board specifically to handle good faith failures. They understood that rigid deadlines could produce unjust results when mistakes were honest. That's why you exist, to exercise judgment, to distinguish between willful non-compliance and honest error. Miguel Santos leaned back in his chair. Ms. Walsh, I've read your petition thoroughly. Your legal research is impeccable. But I have one concern. All 7 of the previous cases you cited involved filing failures that were discovered and corrected within 6 months of the deadline. This failure wasn't discovered until a lawsuit was filed over 4 months after the deadline. That's different. The room went very quiet. This was the angle we'd been worried about, the argument that we'd waited too long, that our petition only came after Malcolm forced the issue. I started to respond, but Dorothy spoke first. Mr. Santos, with respect, that's not quite accurate. The filing failure existed from the moment the deadline passed. It existed whether anyone noticed it or not. The fact that it took 4 months for someone to discover it doesn't change the nature of the failure itself. It was still a good faith mistake, still made by attorneys who believed they'd filed everything necessary. She pulled out another document. And consider the alternative. You're suggesting that if someone with malicious intent deliberately waits to discover and challenge a filing failure, that delay somehow makes the failure worse. That would create a perverse incentive. It would reward bad actors who hold complaints in reserve to maximize damage rather than raising issues promptly. Santos nodded slowly. That's a fair point. Grace Liu had been reading through the documentation about the Foundation's community impact. Now she looked up, and her expression was troubled. I want to understand the practical impact here. Mr. Reeves, if this board denies your petition, what happens to the people currently receiving services from your foundation? This was the question I'd been dreading and hoping for in equal measure. Because the answer was terrible, but it was also the most important truth in this room. Their cases would be transferred to other organizations if possible, I said. But most of those organizations are already operating at capacity. They're already turning people away. So realistically, some cases would be picked up by other groups. Many wouldn't. Those people would have to represent themselves or give up their legal fights entirely. Can you be more specific? Liu pressed. Give me names. Tell me about real people. So I did. I told her about Teresa Morales and her house, about James Miller facing eviction at 80 years old, about the construction worker denied workers' compensation for an on-the-job injury, about the family facing deportation over a paperwork error, about the young woman trying to escape abuse and keep custody of her daughter. I gave her names, ages, circumstances, made them real, made them visible. When I finished, Liu's expression was set in hard lines. Dr. Hammond, she said, I'd like to propose that we go into deliberation now, rather than extending this question period. I think we've heard enough. Hammond looked at the other board members. Fitzgerald and Brenner exchanged glances. Santos nodded. Hammond checked her watch. Very well. We'll deliberate in closed session. Mr. Reeves, Ms. Brooks, Ms. Walsh, you're welcome to wait, though I should warn you that deliberations sometimes take several hours. We'll notify you when we've reached a decision. We'll wait, I said immediately. The board members stood and filed out through a side door to a private conference room. The clerk gestured for us to return to the waiting area, and then there was nothing to do but wait. The waiting area had 4 chairs, a coffee machine that looked like it hadn't been cleaned in a decade, and a stack of magazines from 2019. Jennifer immediately pulled out her phone and started typing notes. Dorothy sat quietly, her hands folded in her lap, looking more peaceful than I felt. I tried to sit. Lasted about 45 seconds before I was pacing. They're going to deny it, I said. Santos's question about the timing, that's the angle they'll use. They'll say we waited too long. Or, Jennifer said without looking up from her phone, Liu's questions about community impact will sway them. She clearly cares about the real-world consequences. 3 out of 5 need to vote yes, I said, still pacing. Hammond seems fair but tough. Fitzgerald is a by-the-book bureaucrat who probably hates anything that looks like bending rules. Brenner seems focused on financial compliance. Santos is a wild card. He's sympathetic but concerned about the timing. Liu is our best shot. Jackson, Dorothy said quietly. Sit down. You're making yourself crazy. I can't sit. I stopped, not sure what I needed to do. Move. Keep moving. Stay in motion, because if I stopped, the weight of everything would crush me. Dorothy stood and walked over to me. She put her hand on my arm, and the gentle pressure of it somehow made me stop pacing. Listen to me, she said. You've done everything you can. We all have. The board has all the information they need to make the right decision. Now it's in their hands, and you standing here wearing a hole in the carpet won't change the outcome. But what if they say yes? What if Grace Liu convinces the others that justice matters more than bureaucratic rigidity? What if Santos's concern about timing gets outweighed by the strength of our precedent cases? What if we win? I looked at her. This woman who'd spent 27 years preparing for a moment that might still end in failure. How are you so calm? I asked. Dorothy smiled. Because I learned something after Henderson. Worrying about outcomes you can't control is just suffering twice, once in anticipation and once in reality if it happens. So I choose not to do that anymore. I did the work. I gave them everything I had. Now I wait with peace instead of panic. I don't know how to do that. You learn, she said. Usually the hard way. Jennifer closed her laptop. Dorothy's right. We've made our case. It was strong. Liu was clearly moved by the community impact testimony. Santos engaged seriously with the legal arguments. Even Fitzgerald and Brenner asked substantive questions instead of dismissive ones. That's all positive. Or they were just being polite before denying us. Jackson. Jennifer's voice was firm. Stop catastrophizing. Yes, we might lose, but we also might win. And driving yourself crazy with worst-case scenarios helps no one. I forced myself to sit down. Checked my phone. It was 10:47 a.m. We'd been in the hearing for an hour and a half. How long did deliberations usually take? Could be anywhere from 30 minutes to 3 hours, Jennifer said, reading my mind. Or longer if they're really divided. What's the longest deliberation on record? For this board? 7 hours. But that was a case involving fraud allegations and millions in missing assets. This is more straightforward. I tried to focus on my phone, answering emails, checking in with the office. But my mind kept drifting back to that conference room, imagining 5 people debating our fate. An hour passed, then 90 minutes. Jennifer went to get coffee from the terrible machine. It tasted like hot sadness, but it was something to do. At 12:23 p.m., the side door opened. The clerk stepped out. The board has reached a decision, she said. Please return to the conference room. My heart stopped, restarted, and immediately tried to beat its way out of my chest. This was it, the moment that would determine whether everything my father built survived or died. We stood, gathered our things, and walked back into that bland conference room where 5 strangers had just decided our future. The board members were already seated, their expressions carefully neutral. Dr. Hammond had a folder in front of her. She waited until we were seated before speaking. The board has completed its deliberation, she said. Before I announce our decision, I want to note that this was not a simple case. We engaged in substantial discussion about the scope of our remedial authority, the precedential impact of our decision, and the balance between regulatory compliance and charitable mission preservation. She opened the folder. The board recognizes that California Corporate Code, Section 5142, subsection 7-C, establishes a clear filing requirement with a specific deadline. We also recognize that William Reeves's estate attorneys failed to meet that deadline, though the evidence suggests this failure was the result of honest error rather than willful negligence. My hands were gripping the chair arms so hard my knuckles had gone white. After reviewing the petition, the supporting documentation, and the testimony provided today, the board has voted on whether to exercise our discretionary authority to accept a late filing under the three-part test established in our enabling statute. Hammond looked up from the folder, her eyes meeting mine. The motion passed by a vote of 3-2. The Charitable Assets Oversight Board hereby accepts the late filing of Form CT-19 for the William Reeves Memorial Foundation. Effective immediately, the trust transfer to Jackson Reeves is deemed complete and valid under California law. For a moment, the words didn't register. They were just sounds, syllables without meaning. Then Jennifer grabbed my arm, her grip painfully tight, and I realized what had just happened. We'd won. We'd actually won. The world didn't shift on its axis. Thunder didn't roll across the sky. There was no dramatic swell of music or slow-motion celebration. Victory, it turned out, felt like being held underwater for months, and suddenly breaking the surface a gasping, desperate rush of air that was relief and disbelief and overwhelming gratitude all tangled together. "Thank you," I managed to say, though my voice sounded strange to my own ears. "Thank you so much," Dr. Hammond held up a hand. "Before you leave, Mr. Reeves, I want to be clear about what we've decided and what we haven't. We've accepted your late filing, which cures the technical defect in the trust transfer. However, this decision comes with conditions." The relief that had started flooding through me suddenly hit a wall. Conditions. The board is concerned about the circumstances that led to this filing failure. While we accept that it was an honest error, it was also a preventable one. Therefore, we're requiring the following. First, the Reeves Foundation must conduct a comprehensive compliance audit within the next 90 days. Second, you must retain a compliance officer whose sole responsibility is ensuring that all state and federal filing requirements are met. Third, you must submit quarterly reports to this board for the next 2 years demonstrating ongoing operational compliance. She looked at me seriously. "This is not a punishment, Mr. Reeves. It's a safeguard. We're accepting your late filing because we believe the Foundation serves an important public purpose. But we're also ensuring that this kind of error doesn't happen again. Are these conditions acceptable to you?" "Absolutely," I said without hesitation. "We'll meet every single requirement." "Good." Hammond closed her folder. "Our written decision will be filed with the court by end of business today. You should coordinate with your attorney regarding next steps in the litigation. Congratulations, Mr. Reeves. Don't make us regret this decision." Grace Liu spoke up for the first time since we'd returned to the room. "Mr. Reeves, can I say something off the record?" Hammond glanced at her, then nodded. "The official proceeding is concluded. Say what you need to say, Grace." Liu looked at me, and there was something fierce in her expression. "I voted yes because of Teresa Morales. Because of James Miller and Amanda Torres and all those other people you told me about. I don't care about legal technicalities or filing deadlines. I care about whether dissolving your foundation would harm people who are already vulnerable. And it would, significantly." She stood, gathering her papers. "Your father built something that matters. Make sure you keep it that way. Make sure those conditions the board imposed aren't just boxes you check, but real improvements that make the foundation stronger. Because if I ever hear that you're not serving those communities anymore, that you've turned this into some vanity project or let it drift from its mission, I will personally petition to have this decision reviewed." It wasn't quite a threat. It was something stronger, a promise. "You won't hear that," I said. "I promise you that." Liu nodded once, then walked out. The other board members filed out behind her, leaving just the three of us and the clerk. Jennifer was already pulling out her phone. I need to call Judge Morrison's clerk immediately. Get this decision filed as part of the court record. Once that's done, Malcolm's case is dead. There's no incomplete transfer anymore, which means there's no basis for dissolution. She stepped out into the hallway, phone already to her ear, voice shifting into professional attorney mode. Dorothy and I sat in silence for a moment. I kept expecting to feel something different: elation, maybe, or triumphant joy. But mostly I just felt exhausted. The kind of exhaustion that comes when you've been holding tension in every muscle for so long that releasing it leaves you hollow. "We did it," I said finally. "You did it," Dorothy corrected gently. "You fought for something worth fighting for. You listened when someone offered help. You didn't give up even when 13 lawyers told you it was hopeless. I couldn't have done any of this without you. You know that, right? Without your research, without you walking into my office that night." "I was in the right place at the right time with the right knowledge," Dorothy said. "But Jackson, here's what you need to understand. I gave you information. You gave those board members a reason to care. When you talked about Teresa and James and Amanda, when you made those case files into actual human beings, that's what convinced Grace Liu. That's what tipped the vote." She stood, picking up her briefcase. "Your father would be proud of you. Not just because you won, but because of how you won. Because you remembered that law is supposed to serve people, not the other way around." My throat was tight. "What happens now? For you, I mean." Dorothy smiled. "I go back to work. I've got a shift tonight starting at 6. Dorothy, you just saved a $300 million foundation. You can't just go back to cleaning offices like nothing happened." "Why not? It's honest work. It pays my bills. And I'm good at it. But you could—" I stopped, not sure how to finish that sentence. "You could work for the foundation?" "Doing what?" She wasn't a lawyer, and being a paralegal required current certifications she didn't have. "You could consult for other organizations." Maybe, but that felt presumptuous to suggest. Dorothy was watching my face, and she laughed softly. "You're trying to figure out how to offer me a job without making it sound like charity. Is it that obvious?" "Very, and I appreciate the impulse. But Jackson, I'm 62 years old. I like my life. I like my routine. I like pushing my cart through empty offices and listening to audiobooks and not having to deal with office politics or billable hours or any of that anymore." She paused. "What I would like, if you're offering, is to stay involved as a consultant on compliance matters. Not a full-time job. Just someone you can call when you have questions about obscure regulations or need historical research on charitable trust law." "Done," I said immediately. "Whatever consulting rate you think is fair, double it." "Don't be ridiculous. I'm not. You saved this foundation. You deserve to be compensated properly for that expertise." We negotiated for a few minutes, Dorothy insisting on reasonable hourly rates, me insisting on paying her what she was actually worth, and eventually settled on a consulting agreement that would bring her in for quarterly compliance reviews and give her a small retainer for being available to answer questions. It wasn't nearly enough for what she'd done, but it was what she was willing to accept. And I'd learned that Dorothy Walsh was not someone you could push into taking more than she believed she'd earned. Jennifer returned, her expression bright with suppressed excitement. "Morrison's clerk confirms receipt of the board's decision. The judge wants to see all parties in her chambers tomorrow at 10 a.m. to officially dismiss Malcolm's petition." "It's over, Jackson." "We won." This time, when she said it, I felt it land. Really felt it. The weight that had been crushing my chest for 4 months suddenly lifted, and I could breathe properly for the first time since my father's funeral. We gathered our materials and walked out of that building into Sacramento sunshine that felt warmer than October had any right to be. The parking lot was half empty, unremarkable. Just another government building on just another Thursday afternoon. But everything had changed. The drive back to Los Angeles should have felt triumphant. We'd won. The foundation was safe. Everything my father had built would continue serving the people who needed it. But I kept thinking about Grace Liu's warning, about how she'd voted yes because of Teresa and James and Amanda, and how she'd promised to personally review the decision if the foundation ever drifted from its mission. "We need to do better," I said suddenly. Jennifer was driving, Dorothy in the passenger seat, me in the back going through emails on my phone. "What do you mean?" Jennifer asked, glancing at me in the rearview mirror. "The board is requiring a compliance audit and quarterly reports. But that's not enough. We need to be better than compliant. We need to be excellent." I pulled up the foundation's current operational metrics on my phone. We're serving 800 people across 12 cities. That's good, but we've got a $300 million endowment. We should be serving 8,000 people, maybe more. "You can't scale up too fast," Jennifer cautioned. "Quality of representation matters. If we take on more cases than our attorneys can handle properly, we're not helping anyone. Then we hire more attorneys, open more firms. My father built this foundation to make a real difference, and right now we're scratching the surface of what we could do." Dorothy turned around in her seat. "Jackson, you just spent 4 months fighting for the foundation's survival. Maybe give yourself a week to breathe before you start revolutionizing everything." But Liu was right. People like Teresa are out there right now, facing impossible situations with no help. Every day we wait is another day someone loses their house, or gets evicted, or gives up on justice because they can't afford to fight. And burning yourself out trying to save everyone won't help anyone, Dorothy said firmly. "You want to honor your father's legacy? Then pace yourself. Build sustainably. Make sure every expansion is thoughtful and strategic, not just a reaction to guilt or pressure." She was right, of course. But the urgency I felt wasn't about guilt. It was about finally being free to actually do the work instead of just fighting to preserve the ability to do it. We stopped for lunch at a diner off Interstate 5, the kind of place that served exactly what you'd expect: burgers, fries, coffee that was strong enough to wake the dead. We slid into a booth by the window, and for the first time in months, I didn't feel like I had to be somewhere else, doing something else, preparing for the next crisis. "So, what actually happens tomorrow?" I asked Jennifer. "With Morrison and Malcolm's team?" "Morrison will formally recognize the board's decision. Caldwell will probably try to argue that the decision is subject to appeal, or that it doesn't moot Malcolm's petition for some reason. Morrison will shut that down. She'll dismiss the case with prejudice, which means Malcolm can't refile based on the same claims. It'll take maybe 15 minutes. And then it's really over? Then it's really over. Malcolm could theoretically appeal Morrison's dismissal, but he'd have no grounds. The board exercised its legitimate statutory authority. The transfer is complete. There's nothing left to challenge." I tried to imagine Seth Malcolm's reaction when he heard the news. The man who'd spent millions trying to destroy the foundation out of spite, who'd assembled an army of lawyers and felt certain he'd win, suddenly losing everything because of a 62-year-old former paralegal and a statute nobody else knew existed. There was a certain poetic justice to it. My phone buzzed. "Riley?" I answered. "Immediately. Tell me you have good news," she said without preamble. "We won. The board accepted the late filing. The foundation is safe." There was a long silence on the other end, and then I heard something that might have been a sob or a laugh or both. "Jackson, Her voice broke. "I've been so scared, trying not to show it, trying to be supportive. But I was terrified you were going to lose everything Dad built." "I know. Me too, but we didn't. We won. How? What happened?" So I told her the whole story while sitting in that diner booth with a burger going cold in front of me. Told her about Dorothy and the research and the Henderson Foundation and the board meeting and Grace Liu's fierce promise to hold us accountable. When I finished, Riley was quiet for a moment. "A cleaning lady saved the foundation." "A former paralegal who happened to be cleaning our offices saved it," I corrected. And we almost missed her. I almost never listened to her. She was invisible, Riley. Just another person in a gray uniform that I saw but never really looked at. And she had the answer the whole time. Dad always said that the smartest people were the ones everyone else ignored. I know, he was right. We talked for a few more minutes before Riley had to get to class. After we hung up, I looked at Dorothy, who'd been quietly eating her soup while I talked. "How does it feel?" I asked. "Finally saving the foundation you couldn't save 27 years ago." Dorothy set down her spoon and thought about it. "Bittersweet," she said finally. "I'm grateful we won. Grateful those people you told the board about will continue getting help. But I also can't stop thinking about the Henderson Foundation, about all the people they could have helped if we'd known then what we know now. You can't change the past. No. But I can make sure the lesson from it isn't wasted." She looked at me seriously. "Jackson, promise me something. Promise me that if you ever encounter someone who seems invisible, someone everyone else overlooks, you'll actually look at them, actually listen. Because you never know what they might know, or who they might become, or how they might help. I promise." "Good. Because that's how you really honor your father's legacy. Not by preserving buildings or bank accounts, but by seeing people the way he saw them as inherently valuable, regardless of their job title or bank balance or education level." We finished lunch and got back on the road. Traffic was light and we made good time. By 4 p.m. we were pulling up to the Foundation's office building in downtown Los Angeles. "I need to brief the staff," I said. "Let them know we won. They've been worried about their jobs, about the clients, about everything." "Go," Jennifer said. "I'll handle filing the appropriate paperwork and coordinating with Morrison's clerk for tomorrow." "Dorothy, can I give you a ride home?" "I appreciate it, but my car is here." I parked this morning before we all drove to Sacramento together. We said our goodbyes in the parking garage awkward, slightly formal. Because how do you properly thank someone who just saved everything that matters to you? Dorothy hugged me briefly, told me to get some sleep, and walked to her car like she'd just finished a normal day at work, instead of winning a legal battle that would affect hundreds of lives. I watched her drive away, then headed up to the office. The staff was waiting. Word had apparently spread that we'd had the board meeting today, and everyone wanted to know the outcome. I walked into the main bullpen area to find 15 people pretending to work, while obviously watching the door. "We won," I said simply. "The board accepted our petition. The foundation is safe." For a moment, there was silence. Then everyone started talking at once, questions, exclamations, a few tears from the older staff members who'd worked with my father. Amanda Torres, who'd driven up from the South Central firm for a meeting today, grabbed me in a hug that nearly knocked me over. "Thank you," she said. "Thank you for fighting for this, for not giving up." "Thank a woman named Dorothy Walsh," I said. "She's the one who found the way forward when everyone else said there wasn't one." I spent the next hour answering questions, explaining what had happened, reassuring everyone that their jobs were secure and the mission would continue. By the time I finally made it to my office, it was after 6 p.m., and I was running on fumes. My desk was exactly as I'd left it that morning, papers scattered, coffee cup with a cold remnant of caffeine in the bottom, family photo of my father and Riley and me at my law school graduation. I picked up the photo, studying my father's face. He looked proud in that picture. Proud and maybe a little tired, because he'd worked a full day before driving 3 hours to make my ceremony. "We did it, Dad," I said quietly to the empty office. "We saved what you built. And I'm going to make it better. I'm going to expand it and strengthen it, and make sure it helps more people than you ever dreamed possible." The photo didn't answer, obviously, but I felt something settle in my chest anyway. A sense of peace, maybe, or purpose. Or just the knowledge that I'd faced the worst thing I could imagine, losing everything my father had bled for, and I'd found a way through it. My phone buzzed, a text from an unknown number. "Congratulations on your victory. This isn't over. SM Seth Malcolm. Even in defeat, he couldn't resist making threats. I deleted the message without responding. Because it was over. Maybe Malcolm couldn't accept that, but it was true. The board had ruled. Morrison would dismiss tomorrow, and nothing Malcolm did could change that. I packed up my things and headed home. Tomorrow would bring the official dismissal, the formal end to 4 months of legal hell. Tomorrow I could start focusing on the actual work instead of just fighting for the right to do it. But tonight, I was going to sleep properly for the first time since April. Tonight, I was going to rest in the knowledge that sometimes, not always, but sometimes the good guys actually win. And sometimes they win because a 62-year-old woman in a gray uniform refused to forget. Judge Morrison's chambers were smaller than I'd expected. Oak-paneled walls lined with law books that looked like they'd been there since the building opened. A desk that was organized to the point of being austere. And 3 chairs facing it where Jennifer, Dorothy, and I sat waiting. Malcolm's legal team filled the other side of the room, Caldwell and 2 associates, all wearing expressions that ranged from professionally neutral to barely suppressed frustration. Malcolm himself wasn't present, which somehow made his absence feel more menacing than if he'd been there glaring at us. Morrison entered through a side door at exactly 10 a.m., carrying a thin folder. She sat down without ceremony and got straight to business. I've reviewed the Charitable Assets Oversight Board's decision, which was filed with this court yesterday at 4:47 p.m. The board exercised its statutory authority to accept the late filing of Form CT-19 for the Reeves Foundation Trust transfer. This decision is within the board's discretion and is supported by substantial evidence in the record. She looked at Caldwell. Mr. Caldwell, I assume you're here to argue against dismissal? Caldwell stood. Your Honor, we believe the board's decision is subject to judicial review. The board exceeded its authority by retroactively curing a filing deadline that had passed by more than 4 months. We intend to file an administrative appeal of their decision, and we request that you stay any dismissal of Mr. Malcolm's petition pending resolution of that appeal. On what grounds would you appeal the board's decision? On the grounds that accepting a late filing after litigation has commenced interferes with judicial proceedings and creates an untenable precedent. If the board can simply erase filing deadlines whenever litigation becomes inconvenient for a respondent, then statutory deadlines become meaningless. Morrison made a note. That's an interesting characterization of what happened, Mr. Caldwell. Though I'd point out that the board has explicit statutory authority to accept late filings in cases of good faith error. That authority isn't conditional on whether litigation has been filed. The timing of Mr. Malcolm's lawsuit doesn't eliminate the board's jurisdiction. With respect, Your Honor. Let me finish, counsel. Morrison's voice was sharp. I continued this hearing specifically to allow the board to complete its review. I did so because I recognized that the board's decision would be dispositive of the central issue in Mr. Malcolm's petition. The board has now ruled, and their ruling is well supported by both precedent and the evidence presented. Unless you can show me clear legal error in their decision-making process, I see no grounds for this court to interfere with their administrative determination. Caldwell's jaw tightened. Your Honor, we believe there are grounds for review, and we intend to pursue every available avenue of appeal. But even if the board's decision stands, Mr. Malcolm's petition raises additional issues beyond the filing failure. The petition also challenges Mr. Reeves's competence to manage a $300 million charitable trust, given his limited experience. I felt Jennifer tense beside me. This was a new argument, not something they'd raised before. Morrison's expression went cold. Mr. Caldwell, I've read your petition multiple times. At no point does it challenge Mr. Reeves's competence. Your entire case was built on the filing failure. You don't get to introduce new theories of relief after your primary argument collapses. You're simply grasping at straws because you've lost, counsel. I don't appreciate having my time wasted with last-minute arguments that weren't properly pleaded. Morrison opened her folder and pulled out a single sheet of paper. This court finds that the trust transfer from William Reeves to Jackson Reeves was properly completed following the charitable assets. Oversight Board's acceptance of late filing Mr. Malcolm's petition for dissolution is dismissed with prejudice. Mr. Reeves is confirmed as the lawful trustee and administrator of the Reeves Foundation. She signed the paper with a flourish and looked up at Caldwell. You're free to appeal my ruling or the board's decision or both, Mr. Caldwell. But I suspect you'll find little appetite for overturning an administrative decision that was well within the board's discretion and supported by decades of precedent. We're adjourned. Morrison stood and exited through the same side door she'd entered, leaving us in sudden silence. Caldwell gathered his papers with sharp, angry movements. One of his associates whispered something to him, but he shook his head curtly. When he looked at me, his expression was carefully blank. This isn't over, Mr. Reeves. Mr. Malcolm has extensive resources and a long memory. You may have won this battle, but nothing, Jennifer interrupted, standing up. Your client lost, completely and thoroughly. The board ruled against him. The judge dismissed with prejudice. You can appeal all you want, but you're just burning his money at this point, and we'll be filing for attorney's fees under California's anti-SLAPP provisions, since your petition was clearly intended to intimidate and harass a charitable organization. Caldwell's eyes narrowed. Anti-SLAPP doesn't apply to dissolution proceedings. We'll let a judge decide that. See you in court, Mr. Caldwell. Caldwell and his associates filed out without another word. When they were gone, Jennifer let out a breath that sounded like she'd been holding it since we walked in. Anti-SLAPP? I asked. Is that real? Probably not applicable in this case, but I wanted to rattle him. He was trying to intimidate you with threats of endless appeals. I wanted him to know we'd fight back. Jennifer grinned. Plus, there's actually a decent argument that Malcolm's petition constitutes strategic litigation to punish you for that $40 million judgment he lost. It's worth exploring. Dorothy had been quiet through the whole proceeding, but now she spoke. He's not going to let this go easily. Malcolm? I asked. He's lost. What can he do? Men like Seth Malcolm don't lose gracefully. They retaliate. You need to be prepared for that. Dorothy's expression was troubled. Jackson, you've won the legal battle, but the war might be just beginning. What do you mean? I mean that Malcolm is a billionaire with connections and resources most people can't imagine. He can't take the foundation through legal channels now, so he'll find other ways to hurt you. Other ways to undermine the foundation's work. You need to be ready for that. I wanted to dismiss her concerns as paranoia. We'd won. The case was over. But something in Dorothy's tone made me take her seriously. What kind of retaliation are we talking about? I don't know specifically, but powerful men who've been embarrassed don't just walk away. They find pressure points. They use influence. They turn allies against you or find ways to damage your reputation or create problems that seem unrelated to the original conflict. Dorothy looked at me seriously. Your father had enemies because he fought for people who challenged the powerful. You're inheriting those enemies along with the foundation. Be careful. The warning stayed with me as we left the courthouse. It should have been a day of celebration. We'd won decisively. The foundation was secure. Everything my father built would continue. But Dorothy's words kept circling in my mind. She's probably right, Jennifer said, as we walked to the parking garage. Malcolm didn't get where he is by accepting defeat gracefully. But Jackson, there's a difference between being cautious and being paranoid. Yes, be aware, but don't let fear of what Malcolm might do prevent you from doing your job. What could he realistically do? He's lost all legal standing. The case is dismissed with prejudice. He could try to damage the foundation's reputation. Plant stories in the media about mismanagement or improper use of funds. He could pressure banks or vendors you work with. He could fund opposition to any expansion plans you have. Rich people have lots of tools for making life difficult, even when they can't sue you directly. We reached our cars, and I realized Dorothy had continued walking to her vehicle without saying goodbye. Something about the set of her shoulders looked wrong, tense, worried. "Dorothy!" I called out. "Wait!" She stopped but didn't turn around immediately. When she did, her expression was carefully controlled. "Are you okay?" I asked. "I'm fine. Just tired. It's been an intense few weeks." But her voice didn't match her words. Something was off. "Dorothy, what aren't you telling me?" She hesitated, and in that hesitation I saw genuine fear flicker across her face. "It's probably nothing, just paranoia, like Jennifer said." "Tell me anyway." Dorothy glanced around the parking garage like she was checking to see if anyone was listening. When she spoke, her voice was low. "Last night, after we got back from Sacramento, I went to my night shift like normal. When I got home around 3 a.m., there was a car parked across the street from my house. Expensive car, dark sedan, tinted windows. It was still there when I checked at 4 a.m. before going to bed." My chest tightened. "Did you call the police? And tell them what? That someone parked on a public street? They wouldn't do anything unless the person was actually threatening me." Dorothy shook her head. "It's probably just coincidence, but it felt deliberate, like someone wanted me to know I was being watched." "That's not paranoia," Jennifer said, joining us. "That's intimidation. Classic corporate playbook: make the opposition feel unsafe without doing anything overtly illegal." I pulled out my phone. "I'm calling the police right now." "Jackson, there's nothing they can do. The car was gone by the time I woke up this morning, and I don't have any proof it was connected to Malcolm." "You don't need proof. You need protection." I was already dialing. "If Malcolm is targeting you because you helped us, then the Foundation has a responsibility to make sure you're safe. I'm a consultant who helped with one case. You don't owe me personal security." "We owe you everything," I said flatly. "Without you, we'd have lost. If Malcolm knows that, and he probably does, since we cited your research in open court, then you're in danger because of us. That makes it our responsibility." I spent the next hour coordinating with a private security firm that specialized in protective services. By noon, Dorothy's house had a security camera system being installed and a patrol car doing regular drive-bys. It cost more than I probably should have authorized without board approval, but I didn't care. Dorothy protested at first, but eventually she accepted that it was happening whether she liked it or not. "You're as stubborn as your father was," she said, but there was relief in her voice. I learned from the best. I walked her to her car. "Dorothy, if anything else happens, anything that feels wrong or threatening or even just weird, you call me immediately." "Okay? Okay, I mean it. Day or night. I don't care if it seems like nothing. If your gut tells you something's wrong, I want to know." She nodded, got in her car, and drove away. I watched until she was out of sight, then turned to Jennifer. "We need to assume Malcolm is going to come after us in other ways. What's our exposure? Where are we vulnerable?" Jennifer thought about it. "Financial audit would be the most obvious angle. If he can find any irregularity in how we're spending foundation money, he could report it to regulatory authorities. Create investigations, even if there's nothing actually wrong. So we need to be spotless. More than spotless. Already working on it." The board required a comprehensive compliance audit anyway. I'm bringing in one of the top nonprofit auditing firms in the state. We'll document every penny, every decision, every expense. If Malcolm tries to claim financial impropriety, we'll have bulletproof records showing otherwise. What else? PR. Malcolm could try to damage the Foundation's reputation publicly. We need to be proactive about that. Get ahead of any narrative he might try to spin. Maybe do some positive press stories about clients we've helped, attorneys doing good work, the Foundation's expansion plans. I nodded slowly. Get me a list of journalists who cover nonprofit work and access to justice issues. I'll start doing interviews. Put a human face on what the Foundation does. Good. And Jackson? Document everything. Every threat. every suspicious incident, every attempt at intimidation. Because if Malcolm does cross a legal line, and men like him often do when they get desperate, we want evidence. We spent the rest of the day at the office putting protective measures in place. Enhanced security for our facilities, new protocols for financial documentation, media strategy for positive coverage. I briefed the senior staff on the situation without creating panic, emphasizing that we were being cautious, not responding to specific threats. By 6 p.m., I was exhausted again. The adrenaline from the morning's victory had long since worn off, replaced by the grinding awareness that winning one battle didn't mean the war was over. My phone rang as I was packing up to leave. Unknown number. I almost didn't answer, but something made me pick up. Jackson Reeves. Mr. Reeves, this is Seth Malcolm. The voice was smooth, cultured, with an edge of steel underneath. I wanted to congratulate you personally on your victory. I froze. Mr. Malcolm, I wasn't expecting to hear from you directly. No, I imagine you weren't. But I believe in addressing matters personally when possible. There was a pause. You've won an impressive legal victory. Your attorney found a remedy my team missed. I respect that. Thank you, I said carefully, not trusting this at all. However, I want to make something clear. The lawsuit may be over, but my issue with your foundation remains unresolved. You cost me $40 million with that wrongful termination judgment. Did you think I'd simply forget that? The judgment was fair. Your subsidiary illegally fired 63 people to boost quarterly profits. They deserved compensation, perhaps. But that's not really the point, is it? The point is that you made an enemy of me. And I'm not someone you want as an enemy, Mr. Reeves. My hand tightened on the phone. Is that a threat? It's a statement of fact. I have resources you can't imagine. Connections in every industry, every level of government. I can make things very difficult for your foundation without ever filing another lawsuit. I can make life uncomfortable for you personally. I can. You can do whatever you want, I interrupted, surprised by the steadiness in my own voice. But it won't change anything. The foundation is secure. The work continues. And nothing you do will make me regret standing up to you. Malcolm laughed, a cold sound that made my skin crawl. Such bravado. Your father had that same quality, that insufferable moral certainty that what he was doing was righteous and therefore unassailable. Do you know what happened to your father, Mr. Reeves? He had a heart attack defending a client. He worked himself to death at 63 because he couldn't accept that some battles aren't worth fighting. He could have settled that case. My lawyers offered very generous terms, but he refused. He pushed forward out of stubbornness and pride, and it killed him. Malcolm's voice dropped lower. I'd hate to see you follow in his footsteps, literally. The threat was barely veiled now. I should have been scared, should have felt intimidated by this billionaire with his resources and connections and willingness to destroy people who crossed him. Instead, I felt something else. Anger. Clear, focused, righteous anger. Mr. Malcolm, let me make something equally clear. My father died fighting for what he believed in. If I have to do the same, then so be it. But I'm not backing down. I'm not settling. And I'm not going to be intimidated by thinly veiled threats from a man who's angry he finally lost something. You're making a mistake, Mr. Reeves. Maybe, but it's my mistake to make. Goodbye, Mr. Malcolm. I hung up before he could respond. My hand was shaking adrenaline, or fear, or fury, I wasn't sure. I immediately called Jennifer and told her about the conversation, which she recorded in her notes as potential evidence of harassment. He's desperate, Jennifer said. That call was stupid on his part. He gave us documentation that he's targeting you personally. If anything happens to you or the foundation now, he's the first person investigators will look at. Unless he's smart enough to make it look like accidents or coincidences. Then we stay alert. We document everything. And we don't give him any legitimate ammunition. Jennifer's voice softened. Jackson, are you okay? That had to be unsettling. I'm fine. Angry, but fine. I looked around my office, my father's office, really, though I was finally starting to think of it as mine. He mentioned my father. Said he worked himself to death out of stubbornness. Your father died defending someone who needed him. That's not stubbornness. That's dedication. Malcolm made it sound like Dad could have avoided it, like he chose to die by refusing to settle. Jennifer was quiet for a moment. Your father made choices about what mattered to him. He decided some principles were worth fighting for regardless of personal cost. You can disagree with that philosophy, but you can't call it stubbornness. It was courage. After we hung up, I sat alone in the office as darkness fell outside. The building was emptying out, staff heading home, cleaning crew starting their rounds. Somewhere in this building, someone in a gray uniform was pushing a cart and emptying trash cans, invisible to everyone around them. But not to me. Not anymore. I'd learned that the most important people are often the ones everyone else overlooks. That expertise comes in unexpected packages. That threatening a former paralegal who'd spent 27 years preparing for this moment was Seth Malcolm's biggest mistake. Because Dorothy had saved us once. And if Malcolm came after us again through intimidation or manipulation or any other means, I had a feeling she'd find a way to save us again. My phone buzzed. A text from Dorothy. Security system is installed. Feels excessive, but I appreciate it. Get some rest. Tomorrow we start making the foundation better, not just saving it. She was right. We'd spent 4 months in survival mode, fighting just to exist. Now it was time to actually build something, but first, I needed to make sure everyone involved in that fight was safe from a billionaire who couldn't accept defeat. I locked up the office and headed home, watching the rearview mirror the whole drive, wondering if the expensive dark sedan that pulled out behind me 3 blocks from the office was just coincidence, or if Dorothy's warning about retaliation was already coming true. The paranoia lasted 3 weeks. 3 weeks of checking mirrors obsessively, of jumping at unexpected sounds, of Dorothy calling me every morning to confirm she was okay. 3 weeks of waiting for Malcolm's next move, the attack that never came. The dark sedan I'd seen that first night belonged to a new associate at a law firm 2 floors below ours, who happened to live in the same direction I drove. The mysterious car outside Dorothy's house never appeared again after the security system was installed. The sense that we were being watched, monitored, targeted, gradually faded into the background noise of normal life. Either he's playing a very long game, Jennifer said during our weekly strategy meeting in mid-November, or Caldwell convinced him that further action would be counterproductive. The dismissal with prejudice is on the record. Any obvious retaliation now would just give us ammunition if we decided to file harassment charges. Or he's shifted to methods we can't see, I countered. Quiet pressure on donors, whisper campaigns about mismanagement, subtle undermining that won't be obvious until it's too late. Dorothy, who'd started attending these meetings in her new role as compliance consultant, shook her head. Jackson, you can't live like this. Yes, Malcolm is a threat. Yes, we need to stay vigilant. But you're turning into someone who sees enemies in every shadow. That's no way to run a foundation. She's right, Jennifer agreed. We've got excellent security measures in place. We're conducting the most thorough financial audit in the Foundation's history. We've been proactive with positive media coverage. At some point, you need to trust that we've done enough and focus on the actual mission. I knew they were right, but letting go of the fear was harder than I'd expected. For 4 months, I'd been fighting for the Foundation's survival. For 3 weeks after that, I'd been preparing for the next attack. Now they were asking me to just relax and do normal work. What if I miss something? What if we drop our guard, and that's when he strikes? Then we deal with it when it happens, Dorothy said firmly. But Jackson, if you spend all your energy preparing for attacks that might never come, you're letting Malcolm win anyway. He doesn't have to destroy the Foundation if he can destroy your ability to run it effectively. Fear is just as paralyzing as an actual threat. She pulled out a folder and set it on the conference table. I've been reviewing the Foundation's current operations and the board's requirements for expansion. I have some recommendations. This was the Dorothy I'd come to know: practical, focused, turning abstract anxiety into concrete action plans. First, she said, opening the folder, the compliance audit. I've been working with the auditing firm, and they're incredibly thorough. We'll have a complete report by December 15th, but I can tell you now that they're finding minimal issues. Some documentation gaps from before your father's death, a few expense classifications that should be tightened up, but nothing that suggests mismanagement. So Malcolm won't find ammunition there, Jennifer said with satisfaction. Correct. Second, staffing. You mentioned wanting to expand services, but you need infrastructure first. I recommend hiring that compliance officer. The board required someone whose full-time job is making sure we never have another filing failure. I also recommend bringing on a development director to handle fundraising and donor relations. The endowment is substantial, but growing it will let you expand without depleting the principal. I made notes as she talked. What about legal staff? We're turning away cases because we don't have enough attorneys. That's third on my list. But here's what I've learned from researching other successful legal aid foundations. You don't just need more attorneys. You need better systems. Right now, each firm operates semi-independently, which means you're reinventing the wheel in 12 different cities. You need standardized intake procedures, shared case management software, regular training protocols. Efficiency matters as much as headcount. She pulled out another document. I've drafted a proposed organizational structure that would create a centralized support system while maintaining local autonomy for case decisions. It would let you serve more people with the same number of attorneys, and it would make expansion to new cities much more streamlined. I stared at the document. It was comprehensive, detailed, and exactly the kind of strategic planning the foundation needed. Dorothy, I said slowly, this is way beyond compliance consulting. This is organizational management at a level that requires expertise I happen to have, she finished. Before I left the legal field, I wasn't just a paralegal. I was office manager for a mid-sized firm. I handled operations, staffing, efficiency systems, all of it. I know how legal organizations work, and I know how to make them work better. Jennifer was reading the proposal, her eyes moving quickly across the pages. This is brilliant. Jackson, if we implement even half of these recommendations, we could probably double our case capacity within a year. Then, let's implement all of them, I said. Dorothy, I need you to do more than quarterly compliance reviews. I need you to actually help build this infrastructure. Full-time position, proper salary, whatever title you want. Dorothy hesitated, and I saw that same reluctance from before, the resistance to taking more than she thought she'd earned. I'm serious, I pressed. You're not just someone who helped us win a legal case. You're someone who understands how organizations function, who's been studying charitable foundations for decades, who has expertise we desperately need. The foundation should be paying you what that expertise is worth. I'm 62 years old. I haven't held a professional position in 20 years, and you've spent those 20 years gaining perspective and knowledge that people half your age don't have. That's an asset, not a liability. I looked at Jennifer. Back me up here. He's right, Dorothy. What you've put together in 3 weeks is better than proposals I've seen from consulting firms that charge 6 figures. The foundation needs you, not as a favor or charity, but because you're genuinely the best person for this job. Dorothy was quiet for a long moment, looking at the organizational structure she'd created. When she looked up, her eyes were bright. 3 days a week, she said finally. I'm not ready to give up my independence completely, but I can give you 3 days a week as Director of Operations and Compliance. The other 4 days are mine for my grandson, for my own projects, for maintaining the life I've built. Deal, I said immediately. When can you start? I already have, Dorothy said with a small smile. This proposal didn't write itself. By December, the Foundation's transformation was well underway. The compliance audit came back with exactly the results. Dorothy had predicted minor issues, easily correctable, nothing that suggested mismanagement. We implemented every recommendation, hired a full-time compliance officer named Rebecca Martinez, who'd spent 15 years with the California Attorney General's nonprofit oversight division, and established quarterly review protocols that would prevent any future filing failures. We brought on a development director, Marcus. I stopped myself. Not Marcus. We brought on David Chen. Wait, no. No Chen. David Morrison, a fundraising professional who'd worked with several major charitable organizations and believed in our mission enough to take a salary cut to join us. And we started implementing Dorothy's operational improvements. The centralized case management system went live in January. Within a month, our intake processing time dropped by 40%. Attorneys were spending less time on administrative work and more time actually helping clients. The firms started sharing resources, one city's expertise in housing law helping another city's cases, immigration specialists consulting across state lines, a knowledge base that grew stronger with each case. By March, we were ready to expand. Jennifer, Dorothy, and I stood in an empty storefront in Oakland, California, looking at what would become the Foundation's 13th legal aid firm. This neighborhood needs it, the property manager told us, a woman named Patricia who'd been working in community development for 30 years. We've got immigrant families facing deportation, tenants dealing with predatory landlords, workers being exploited because they don't know their rights. The closest legal aid is 45 minutes away by bus, and most people can't afford the time off work to get there. That's exactly why we're here, I said. How fast can we get the space ready? Contractors say 6 weeks if you pay premium. Rates: 3 months if you go standard. Premium rates, I decided. Every week we wait is another week people go without help they need. Dorothy made a note on her tablet. I'll coordinate with Jennifer on hiring. We should aim for 2 full-time attorneys and a paralegal to start, with plans to expand once we're established. Patricia, can you help us connect with community organizations? We want people to know we're coming before we open doors. I can. Do that. There's a coalition of immigrant advocacy groups that meets monthly. I'll get you on the agenda for their next meeting. We spent another hour discussing logistics office layout, security systems, intake procedures before heading back to the car. As we drove out of the neighborhood, I watched people going about their daily lives, parents walking kids to school, workers waiting at bus stops, small businesses opening for the day. How many of them would need us at some point? How many were already facing legal problems they didn't know how to solve? You're thinking too much again, Dorothy said from the passenger seat. She'd started reading my expressions with unsettling accuracy over the past few months. I'm thinking about scale, about how many people need help, and how few of them get it. You can't save everyone, Jackson. I know. But we can save more than we're saving now. That Oakland firm will help maybe 500 people a year once it's fully operational. That's 500 lives that are better because we expanded. How many more neighborhoods are there like that one? How many more firms? Should we be opening? Dorothy was quiet for a moment. Your father asked himself the same questions. He wanted to help everyone too, but he learned eventually that sustainable growth matters more than rapid expansion. If you open too many firms too fast, quality suffers. You spread resources too thin. You risk becoming the thing you're fighting against, an organization that processes people instead of helping them. She was right, as usual. But the urgency still gnawed at me. The board's quarterly report is due next week, Dorothy continued. Let's show them what we've accomplished with the Oakland expansion. Demonstrate that we can grow thoughtfully and effectively. Build trust. Then, maybe in 6 months, we propose another expansion. And 6 months after that, another. Steady growth. That's financially sustainable and operationally sound. That's patient, I said. I'm not good at patient. I know. But you're learning. Dorothy smiled. Your father wasn't good at patient either, by the way. He drove his staff crazy with his urgency, always pushing for more, faster, bigger. It was one of his strengths and one of his weaknesses. Was April now a full year since my father's death? The foundation had survived its existential crisis, expanded its operations, and was stronger than it had ever been. We were helping more people, working more efficiently, and building something that would last beyond any single person's lifetime. But there was still something hollow in the victory, something incomplete. I'd spent a year fighting to preserve my father's legacy. But what was my legacy going to be? What would I build that was mine, not just a continuation of his work? The question haunted me as we prepared for the board's quarterly review. We had good news to report, exceptional news, really. But I couldn't shake the feeling that maintaining wasn't enough, that there was something bigger we should be doing. You seem distracted, Jennifer said the night before the board presentation. We were in the office late, going over slides for the 100th time. Just thinking about what comes next. After we open Oakland, after we've checked all the board's boxes, after we've proven the foundation is stable and growing. Then what? Then we keep doing it. We keep helping people. That's the point, isn't it? But is it enough? My father built this foundation from nothing. He created something revolutionary. What am I creating? Better processes? Efficiency improvements? Those are important, but they're not transformative, Jennifer finished. You want to do something that changes the game entirely, not just plays it better. Yes, exactly that. Jennifer set down the presentation remote. Okay, so what would game-changing look like? If you could do anything, if resources and politics and logistics weren't constraints, what would you build? I thought about it. About Teresa Morales almost losing her house. About Amanda Torres working herself to exhaustion because there weren't enough attorneys. About the hundreds of people in waiting rooms across 12 cities, all needing help that was too scarce and too slow. I'd make legal representation a genuine right instead of a theoretical one, I said slowly. The Constitution says you have the right to an attorney in criminal cases. But in civil cases, evictions, custody battles, consumer fraud, workplace violations, you're on your own unless you can afford to pay. That's not justice. That's just a system where money determines outcomes. So you want to, what? Lobby for constitutional reform? No, I want to build a model that proves it can work. A city where every person, regardless of income, has access to real legal representation for any civil matter. Not just emergency cases or obvious injustices, everything. Jennifer stared at me. Jackson, that would cost millions. I know, maybe tens of millions depending on the city's size. But we have a $300 million endowment. What if we took a real swing at this? Picked one city, partnered with local government and other legal aid organizations, and built a comprehensive system that actually worked? It would be controversial. It would be attacked from every angle. And it might fail spectacularly. But if it worked, if we could prove that universal civil legal representation is actually achievable, we'd change the entire conversation about access to justice in this country. We'd give other cities a model to copy. We'd move the needle in a way that incremental. Improvements never could. Jennifer was thinking. I could see it in her expression. You'd need buy-in from local government, partnership with law schools for formal programs, technology infrastructure for case management at scale, community outreach to make sure people knew the system existed. And you'd need to choose the right city, somewhere big enough to matter, but small enough to be manageable. Help me research it, I said. Do a feasibility study. Figure out what it would actually take to make this work. And if it's possible, if there's a genuine path forward, then we propose it to the board. This is insane, Jennifer said, but she was smiling. Your father would have loved it. He always said the biggest mistake lawyers make is thinking too small. Then let's think big. We worked until 2 in the morning, sketching out concepts and researching similar efforts in other countries. By the time I finally went home, my exhaustion was mixed with something I hadn't felt in a long time. Excitement. Real, genuine excitement about building something that could matter. The quarterly board presentation the next day went smoothly. We showed them the Oakland expansion plans, the operational improvements, the financial health of the foundation. Dr. Hammond and the other board members asked tough questions, but seemed satisfied with our answers. At the end, Grace Liu spoke up. Mr. Reeves, I have to say, the transformation over the past 6 months has been remarkable. You've not only met every requirement we imposed, but exceeded them. The foundation is stronger now than when your father ran it. That's generous of you to say, but my father... Your father built something incredible, Liu interrupted, but he built it as one man with a vision. You're building an institution that can outlast any single person. That's different. That's arguably more important. She leaned forward. I was the vote that almost went the other way last November. I believed in your mission, but I wasn't sure you had the management expertise to handle an organization this size. I was wrong. You've proven you can not only manage it, but grow it thoughtfully. I wanted you to know that. The praise should have felt good. Should have felt like validation of everything I'd worked for. Instead, it felt like a weight. Because managing and growing weren't enough. I wanted to transform. Thank you, I said. That means a lot, and I hope you'll feel the same way when we bring you our next big proposal. Hammond raised an eyebrow. What proposal? I'll have details in 3 months, but I want to explore something ambitious, something that goes beyond incremental improvement, to actually changing how access to justice works in this country. That's vague, Mr. Reeves. It is, because I want to do the research first, make sure it's actually feasible. But I promise you this, when we bring it to you, it'll be worth the wait. The board members exchanged glances. Santos looked intrigued. Brenner looked skeptical. Liu was smiling like she'd suspected I was planning something like this. We look forward to seeing it, Hammond said diplomatically. Meeting adjourned. As everyone filed out, Dorothy lingered behind. A city with universal, civil legal representation. That's the big proposal you're planning, isn't it? How did you know? Because it's exactly the kind of crazy ambitious thing your father would have proposed, and exactly the kind of project that could actually change things if it worked. Dorothy looked at me seriously. But Jackson, something this big will make waves. It'll challenge the entire legal services industry. It'll threaten private attorneys who make money off civil cases. It'll require political capital you might not have. I know. And it'll put you in Malcolm's crosshairs again. Because men like him don't want a world where everyone has equal access to justice. That world is bad for their business model. I know that too. Dorothy nodded slowly. Okay then. Just wanted to make sure you understood what you're getting into. Because this isn't going to be another filing failure we can fix with research, and a good petition. This is going to be a fight. A big, public, probably ugly fight. Then it's a good thing I know a woman who's been preparing for fights like this for 27 years, I said. Dorothy smiled. I suppose it is. So when do we start? Tomorrow. But tonight, I need to do something first. I drove to the cemetery where my father was buried. I hadn't been since the funeral, couldn't bring myself to face it during those first terrible months. But now, with the foundation secure and a new vision taking shape, it felt like time. The grave was simple. Just a stone with his name, dates, and a single line he'd requested years ago. He fought for those who couldn't fight for themselves. I sat down on the grass next to it, not caring about the damp or the cold. "Hey, Dad," I said to the stone. "It's been a year. A really complicated, terrifying, exhausting year. But we made it. The foundation survived. And now we're going to make it better. Make it something even bigger than what you built." The stone didn't answer, obviously. But sitting there in the fading light, I felt something settle in my chest. The fear that had been my constant companion for months, finally, fully released its grip. I'd proven I could preserve what my father built. Now it was time to prove I could build something of my own. Something that would make Grace Lou say, "Wow." Something that would terrify Seth Malcolm. Something that would actually change the world. And all because a 62-year-old woman in a gray uniform had walked into my office one night and refused to let me give up. 3 years later, the mayor of Riverside, California, stood at the podium in front of 200 people, reporters, city council members, legal professionals, and community advocates, all gathered to witness something that had never been done before in American history. "Today," Mayor Rebecca Thornton said, her voice carrying across the crowded community center, "Riverside becomes the first city in the United States to guarantee universal civil legal representation to every resident, regardless of income. No one will face eviction, custody battles, consumer fraud, or workplace violations without access to real legal help. This isn't a pilot program. This isn't an experiment. This is a fundamental reimagining of what justice means." I stood off, to the side of the stage, watching it happen. 3 years of planning, negotiating, building, and fighting had led to this moment. 3 years of opposition from private bar associations who saw us as competition. 3 years of skeptical city councils who thought it was too expensive. 3 years of Seth Malcolm trying and failing to undermine us at every turn. But we'd done it. The Riverside Justice Initiative, as we'd named it, was a partnership between the Reeves Foundation, the city government, 3 local law schools, and a coalition of community organizations. We'd hired 47 attorneys, trained 200 law student firms, built a technology platform that streamlined intake and case management, and created a model that could be replicated in cities across the country. And it had all started with a conversation in my office at 2 in the morning with Jennifer and a crazy idea that seemed impossible. "Mr. Reeves," Mayor Thornton said, gesturing to me, "would you like to say a few words?" I walked to the podium, looking out at the crowd. I recognized faces: Dorothy sitting in the 3rd row with her grandson Tyler, now 17 and already accepted, to 3 engineering programs. Amanda Torres, who'd been promoted to director of the South Central firm and had helped design the Riverside model. Jennifer Brooks, who'd spent 3 years as our lead counsel on this project and had somehow maintained her sanity. Teresa Morales, who'd kept her house and had volunteered to be one of the first community advocates for the new system, and in the back row, trying to be invisible but failing because I'd learned to see them now, 3 cleaning staff in gray uniforms who'd taken time from their shifts to witness this moment. 4 years ago, I began. I inherited a foundation that was about to be destroyed. 13 lawyers told me there was no way to save it. I believed them. I'd given up. I looked at Dorothy, and then a woman, who everyone else overlooked a cleaning lady with an 8th-grade education on her employment records, walked into my office at midnight and showed me that sometimes the most important expertise comes from the people nobody thinks to ask. Dorothy was smiling, her eyes bright with tears she wouldn't let fall in public. Dorothy Walsh spent 27 years preparing for a moment that hadn't arrived yet. She studied a legal problem that no one else cared about. She kept files and research that seemed pointless. She remembered things that everyone else forgot. And when the moment finally came, when someone needed exactly what she knew, she spoke up. I paused, making sure people were really listening. The lesson I learned from Dorothy wasn't about charitable trust law or filing deadlines. It was about seeing people, really seeing them. Because the person who saves your life might not look like you expect. They might be wearing a uniform you've trained yourself to look past. They might be doing a job our society has decided is menial or unimportant. But their knowledge, their expertise, their humanity, those things are there whether we choose to see them or not. I gestured to the room around us. This initiative exists because we learned to see people others overlook. The single mother facing eviction who became one of our most effective community advocates. The formerly incarcerated man who now trains our intake specialists because he understands the system from the inside. The immigrant workers who taught us how to build trust with communities that have been failed by legal systems before. My voice grew stronger. Access to justice isn't just a legal principle. It's a recognition that every person, regardless of their bank account, their education, their job title, or their social status, deserves to be seen, heard, and helped. That's what my father believed. That's what Dorothy showed me. And that's what we're building here in Riverside. The applause was immediate and genuine. Mayor Thornton returned to the podium, and I stepped back, finding my way to where Jennifer and Dorothy were standing. "That was perfect," Jennifer whispered. "Though you're going to make Dorothy cry." "I'm not crying," Dorothy said, even though she clearly was. "I just have something in my eye." "Both eyes," I teased. "Shut up and let me have my moment." The ceremony continued with speeches from city council members and law school deans and community leaders. I only half listened, my mind already moving, to what came next, because Riverside was just the beginning. 5 other cities had already approached us about replicating the model. 2 state legislators were drafting bills to study statewide implementation. The conversation was shifting from "Is universal civil legal representation possible?" to "How fast can we make it happen?" Seth Malcolm had tried to stop us, of course. He'd funded opposition groups, planted negative stories in conservative media, pressured donors to withdraw support. But he'd underestimated something crucial. People cared about this. Real people who'd been screwed by systems designed to favor the powerful had rallied behind the initiative. And no amount of Malcolm's money could drown out their voices. The last time I'd heard from him was 6 months ago, a brief, bitter phone call where he'd accused me of destroying the legal profession by making attorneys provide charity. "I'm not providing charity," I'd told him. "I'm providing justice. There's a difference." He'd hung up without responding. I hadn't heard from him since. After the ceremony, there was a reception with mediocre coffee and grocery store sheet cake. The kind of event that had become familiar over years of community organizing. I worked the room, shaking hands, answering questions, accepting congratulations. A young woman approached me, maybe 25, with a child balanced on her hip. "Mr. Reeves? I'm Carmen Silva. I just wanted to thank you. My landlord was trying." To evict me illegally said I owed back rent that I'd already paid. I couldn't afford a lawyer, and I thought I'd lose my apartment and my daughter and everything. But your firm took my case. They fought for me. I kept my home because of you. The child on her hip, maybe 2 years old, looked at me with solemn eyes that had seen too much for someone so young. I'm glad we could help, I said. But Carmen, you should know it wasn't really me. It was attorneys like Amanda Torres who did the actual work. I just helped create the system that made it possible. You created a system where people like me matter, Carmen said fiercely, where we're not just disposable. That's worth thanking you for. She walked away before I could respond, but her words stayed with me. That's what this was really about, not legal technicalities or organizational models or even access to justice. In the abstract, it was about making people feel like they mattered, like their lives had value, like someone would fight for them. My father had understood that. Dorothy had shown me how to see it, and now we were building a system that encoded it into policy. Tyler Walsh, Dorothy's grandson, found me near the refreshment table. He'd grown tall in the 4 years since I'd first heard his name, almost 6 feet now, with his grandmother's sharp eyes and her careful way of observing before speaking. "Mr. Reeves," he said formally, then grinned. "Or should I call you Jackson, since we're practically family now?" "Jackson is fine. How's school?" "Good. I got my acceptance letters." His grin widened. "MIT offered me a full scholarship for mechanical engineering. Tyler, that's incredible. Does your grandmother know?" "She was the first person I told. She cried for like an hour." He shook his head fondly. "She keeps telling everyone who will listen that her grandson is going to MIT. It's kind of embarrassing, but also kind of great. She should be proud. And Tyler," I paused, wanting to say this right, "your grandmother told me once that foundation helped you when you were in trouble at school, gave you a second chance. I want you to know that the second chance went both ways. You being helped by us is part of why she was willing to help us when we needed it. So in a weird way, you helped save the foundation." Tyler looked uncomfortable with the praise. "I just made a stupid mistake and got lucky someone gave me another shot." "That's not luck. That's what happens when systems are designed to help people instead of punish them. Remember that when you're at MIT designing the future. Build things that give people second chances." "I will," Tyler promised. "And Mr. Reeves, thank you for everything you've done for my grandmother. She's happier now than I've seen her since my grandfather died. Having real work again, work that matters, it's given her purpose." He walked away to find Dorothy, and I felt that familiar tightness in my throat that came whenever I thought about how close we'd come to losing everything. If I hadn't been in the office that night, if Dorothy hadn't decided to speak up, if I hadn't listened, the foundation would be gone. The Oakland firm would never have opened. The Riverside Initiative wouldn't exist. Thousands of people wouldn't have gotten help they desperately needed. All because of a filing deadline and a woman who refused to forget. Jennifer found me as the reception was winding down. "The mayor wants to do a press conference tomorrow. National media is picking up the story. This is going to be big, Jackson." "Good. It should be big. This is important. It's also going to make you a target again. Malcolm's going to hate the attention this brings, and there are other powerful people who benefit from the current system staying exactly as broken as it is." "Let them come," I said. "We've got something they don't have." "What's that?" "We've got Dorothy," Jennifer laughed. "That's true, and honestly, that's probably enough." Dorothy was saying goodbye to Tyler, sending him back to school with the kind of fussing that grandmothers specialize in. When he'd left, she made her way over to us, looking tired but satisfied. "This is a good day," she said simply. "It's a great day," I corrected. "And it wouldn't exist without you." "Oh, stop! I found one old statute. You built an entire system." "You did more than find a statute, Dorothy. You taught me to see people. You showed me that expertise and wisdom come in unexpected packages. You refused to accept that justice was impossible just because 13 lawyers said it was." I looked at her seriously. "Everything we've built, the firms, the expansion, this initiative, it all traces back to that night you walked into my office and refused to let me give up." Dorothy was quiet for a moment. When she spoke, her voice was soft. "I spent 27 years feeling like my knowledge was useless. Like all that research had been a waste of time because there was no one to share it with, no way to use it. And then suddenly, impossibly, there you were, the exact situation I'd been preparing for without knowing it." She smiled. "That's what I want people to understand. That the thing you're learning right now, the expertise you're building, the knowledge, that seems pointless. It might be exactly what someone needs 5 years, or 10 years, or 27 years from now. You don't know when your moment will come. You just have to be ready when it does." "And you were ready," Jennifer said. "I was ready." And Jackson listened. That's the other half of the equation someone has to be willing to hear. Most people in his position would have dismissed me. A cleaning lady with opinions about charitable trust law? That doesn't fit any normal pattern. But he saw past the uniform. He paid attention. We stood there together as the community center emptied out 3 people who'd met under impossible circumstances and somehow changed the world by refusing to accept that some battles couldn't be won. "What's next?" I asked. "Besides terrorizing other cities into adopting our model?" Dorothy pulled out her ever-present tablet. "Well, the board wants a report on sustainability metrics for the Riverside Initiative. We need to prove this isn't just a short-term success, but something that can actually last. Also, I've been thinking about replication strategy." "Dorothy," Jennifer interrupted gently, "Jackson was asking what's next for you personally, not professionally." "Oh," Dorothy blinked. "I don't know. I hadn't thought about it." "Think about it," I said. "Because you're 65 now. You've spent the past 3 years working full-time on this initiative on top of your consulting role. You're allowed to slow down, to retire, to enjoy the fact that you've accomplished something incredible." "Retire?" Dorothy looked horrified. "Why would I retire when we're just getting started? 5 cities are interested in the model. State legislators are paying attention. This could go national if we play it right." "It could," I agreed, "but it doesn't require you personally working 60-hour weeks. We can hire people, build a team. You can transition to an advisory role if you want." Dorothy was quiet, considering. "Can I think about it?" "Of course. Just promise me you'll actually think about it, instead of immediately deciding to keep working yourself to exhaustion." "I promise nothing." We walked out together into the riverside evening. The city stretched around us, a mid-sized California town that had just become the first place in America to truly guarantee justice for everyone. Not perfect justice, not justice that solved every problem, but justice that gave people a fighting chance. My phone buzzed. A text from Riley. "Saw the news coverage. Dad would be so proud. I'm proud too. Love you, big brother." I typed back, "Love you too. Come visit soon. I want to show you what we've built." And one mid-sized California city, where justice was no longer just for those who could afford it. It wasn't enough. It would never be enough until every city, every state, every person had access to real legal representation. But it was a start. My father had built a foundation because he believed everyone deserved a fighter in their corner. I'd preserved that foundation and expanded it into something bigger because a cleaning lady had taught me to see people everyone else overlooked. And somewhere, right now, another Angela Martinez was picking up the phone to ask for help, believing maybe for the first time that someone would actually answer. That was my father's legacy. That was Dorothy's gift to the world. And that was the story of how 13 lawyers failed. But the cleaning lady solved everything in 4 minutes. Not through legal genius or insider knowledge or any kind of magic, but through something much simpler and much more powerful. She remembered what everyone else forgot. She spoke up when staying silent would have been easier. And she proved that sometimes the most important person in any room is the one nobody bothered to notice was there. Remember, true wisdom often comes, not from those with the most impressive credentials, but from those who've spent years quietly learning while others stopped paying attention. The janitor, the receptionist, the person everyone walks past without really seeing, they might be carrying exactly the knowledge that saves you. If only you're humble enough to listen. Never judge expertise by its packaging, because the most valuable help often arrives in the most unexpected forms. And remember, treating every person with dignity isn't just morally right, it's strategically smart, because you never know who might change your life.